So we believe that the project we're discussing today is also represents a very important investment for the future. The third reason why we believe that this project is extremely important and timely is that the Ukrainian government is currently in the process of developing a number of policies and proposals for legislation, the purpose of which is to contribute to the integration of Ukrainians who live on territory which is currently outside the control of the Ukrainian government, and also to pave the way for such things as transitional justice once a political resolution to the conflict is in sight. Now, in order for those policies and those laws to be able to take shape within the context of a solid legal framework, it is extremely important that the conflicts in Ukraine be analyzed from the point of view of international law, in particular the ambiguities that are raised by the nature of this conflict. So for all those three reasons, in order for international law to be, as it were, abreast with political developments on the ground, in order to collect and collate evidence for future use, and in order to allow the Ukrainian government, or to help the Ukrainian government devise policies and legislation which align with international law. Of all those reasons, it is extremely important that this work be done. So with that, I'd just like to thank all of those who are taking part in today's discussion: legal scholars, practitioners, diplomats, members of civil society, and also, of course, global rights compliance for what we believe is extremely important work. Thank you so much.
Thank you very much, Ambassador. So as you've heard, today's conference is about an ongoing project which is entitled International Law and Defining Russia's Involvement in Crimea and Donbass, sponsored by the Swedish MFA, for whose support we are very grateful. So the project is first and foremost about truth. It has often been said that truth is the first casualty of war, but does it have to be? Of course, from the moment that little green men appeared in Crimea, which later turned out to be Russian soldiers, disinformation has been at the heart of the war in Ukraine. This is hardly a controversial proposition. But does that mean that Ukraine or its international partners and allies have to fall prey to this misinformation, or that truth, along with peace and security, has to be hidden, or worse, even lost? The project premise is that this is not inevitable. Our legal project asks the question, how can international law be harnessed to help promote the truth and help Ukraine protect its sovereignty and territorial integrity? So our project is premised on a simple proposition. The key to fortifying resistance to Russia's involvement in Ukraine is, at least in part, to be found in international law. Ukraine must respond to warfare with lawfare. At a minimum, Ukraine must seek to demonstrate the legal truth of Russia's involvement in Ukraine, including any violations of international law. Of course, such an approach may seem like an underwhelming response to a war that is now in its 7th year and has already claimed over 13,000 Ukrainian lives. Unfortunately, such criticisms are obviously partly true. Nonetheless, when neither force nor reason have produced answers, lawfare can at least provide a bedrock of legal principle and a record for posterity, which is the bare minimum, we believe, required for accountability and redress. In relation to Crimea, Russia is clearly recognized internationally as an occupying power. However, it is less clear how the legal regime impacts the various rights and duties that fall upon Russia, and also, latterly, those that remain upon Ukraine. These concerns merit a fulsome legal inquiry, including an assessment of the nature of any international humanitarian law and human rights law obligations, and any failure to adhere to such obligations and the legal consequences thereof, As regards Donbass, the government of Ukraine has asserted that Russia occupies this area through its control over separatist forces. Internationally, however, only the Parliamentary Assembly of the Council of Europe has expressly agreed and labelled the area as the temporarily occupied territories. These questions also deserve a fulsome legal analysis. Now, of course, some of these questions will in due course be answered as a consequence of the Ukrainian government's lawfare, including at the International Criminal Court, the ICJ, the European Court of Human Rights, and pursuant to the United Nations Convention on the Law of the Sea. But as the Kremlin is assiduously aware, these institutions are limited by jurisdiction and often delay. Ukraine cannot rely upon only its lawfare at these institutions, however skillful. These mechanisms, however vital, will not provide a comprehensive answer to the many questions of international law that pertain to Russia's involvement in Ukraine. Some of that burden must fall on international lawyers to help Ukraine to collate the facts, clarify the guiding principles, and draw impartial and independent conclusions. Accordingly, for the last 12 months, as you've heard, GRC has been working with the Ukrainian state authorities, multilateral organizations, and civil society to obtain a comprehensive view of facts relevant to Russia's control over Crimea and involvement in Donbass, including their support for the non-state armed groups, with a view to providing very shortly an assessment of some of the most salient international humanitarian law and human rights questions arising from Russia's involvement. We believe this is not mere conflict classification bereft of real purpose. It is a stepping stone to compiling a record based on legal principle that might provide a principled insight into Russia's responsibility, if they have any, for thousands of deaths and the millions of Ukrainian civilians whose lives have been thrown into turmoil by the conflicts. Embedded in international law principles, we believe that such a record will help to guard against misinformation now and in the future. As the ambassador has just spoken about, these principles will also aid Ukraine in its policies, including its ongoing design of deoccupation and transitional justice strategies. And these legal principles will help Ukraine advance its interstate claims at both the national and the global level, and eventually to seek accountability for harms done. And so we have a fascinating conference, I would say, over the next 3 days. It is a critical step in the learning process, the collation of facts, the analysis of the legal principles, and then the drafting of the opinion I've just spoken about. We have 3 mornings to interrogate some of these legal principles with some of the leading domestic experts, as well as the leading international experts. I really believe we have a fantastic group of experts whose contribution, both at the grassroots level and in the courtroom and at the academic level, is second to none. So day 1, we will look at the questions concerning the legal status of Crimea and Donbass, including questions concerning occupation and self-determination, and belligerent obligations arising from humanitarian law and human rights law obligations. Day 2 will focus on both obligations, international humanitarian law and international human rights law obligations, in relation to specific populations such as IDPs, Crimean Tatars, and third parties as a whole. And we will look at gender-based violence and obligations on third states, corporations, humanitarian organizations, and civil society as a whole. And finally, on day 3, we will drill down to focus on specific accountability, looking at various mechanisms, including the ICJ, the European Court of Human Rights, the International Criminal Court, and the UN human rights regime. And we'll look at various jurisdictions, including national and universal, and how they pertain to Ukraine. So exciting days ahead, I would suggest. So before I turn over to our first panel, just some practical stuff. First, there is simultaneous interpretation. I'm sure I'm speaking too fast for it. So do what I haven't done, which is just be aware that what you're saying is being translated. Look for the globe to the bottom right to find the language you prefer. Secondly, please can everyone, aside from the panelists, keep their audio and video off during the duration of the meeting, except when speaking and after being called upon by the moderator. This will help to keep our tech running smoothly. You can raise your hand, look for the button to do that. I'm sure you're all familiar with that. Whether following from Zoom, Facebook, or YouTube, please feel free to comment or question our panelists. We urge you to do that as much as possible and make this as interactive as possible. And so, having spoken too long, over to our first panel, the legal status of Crimea and Donbass, and Professor Ronen.
Hi, so good morning, everybody. Thank you, Wayne, and thank you, Ambassador Tybert. My name is Yaël Ronen, and I'm Professor of International Law. I teach at the Academic Center for Science and Law in Hod Sharon, and I'm a research fellow at the Minerva Center for Human Rights at the Hebrew University in Jerusalem. And I'm honored and pleased to open this first panel of the conference, which, as Wayne said, focuses on the legal status of Crimea and Donbass. Now, the territories of Crimea and Donbass are characterized differently by different international actors. Crimea is referred to as occupied Ukraine territory, as sovereign Russian territory, or sometimes as disputed territory, which is not a legal term, but one which has appeared in the international discourse. Donbass is referred to as occupied Ukraine territory, as an independent entity, as occupied Russian territory, and not to the exclusion of any of the above, as an area of continuing hostilities. The presentations today will address some of the issues arising from these characterizations. But leaving aside the doctrinal legal questions, disputed status characterization raises a tension between law and politics. On the first hand, the first port of call in order to resolve a territorial dispute requires characterizing it correctly from an international legal perspective. On the other hand, in order to engage effectively with the various actors, in order to protect individuals under their control, it may be more pragmatic, more conducive to speak in terms that are acceptable to those actors. This may mean applying their legal perspective, even if it's not internationally accepted. And this sometimes leads to discourse at different levels. When we listen to the presentations, I invite the audience to consider how this tension plays out, both generally and specifically in the Ukraine cases. Now, as you can see, we have a packed program in this session. Each of our speakers has been requested to speak for no more than 10 minutes so that we have time for discussion. And I do invite the audience to submit questions to the various chat platforms. So let me now introduce our first speaker, Professor Michael Bothe. Michael Bothe is Professor Emeritus of Public Law at Goethe University in Frankfurt am Main, a former president of the International Humanitarian Fact-Finding Commission, and a former president of the German Society for International Law. He served as professor of public international law at the universities of Heidelberg, Hanover, and Frankfurt, and was visiting professor or lecturer at various universities around the world. He served as counsel before the International Court of Justice and the German Federal Constitutional Court. And he's the author of numerous publications on international humanitarian law, international legal questions on the maintenance of international peace and security, international and comparative law. Professor Bothe will speak about the status of the Crimean Peninsula and the law of belligerent occupation. Please, the microphone is yours.
Thank you, Chair. And I'm really grateful for that invitation to join a very important conference on a hot issue of current international relations. speaking on the status of the Crimea Peninsula under international law, I have, of course, to go into many of the consequences of this status. So I apologize to the following speakers if I have to address issues which they will, I'm sure, address more profoundly. Now, let me start with the facts. There is a de facto control over the Crimea Peninsula, which has changed through a series of events starting February 2014. The question is, as a consequence of these events, the de jure control, the sovereignty over the territory, changed as well? If the answer is yes or no, what follows? The fundamental applicable rule is formulated in the Friendly Relations Declaration of the General Assembly of 1970, which constitutes, and it is important to emphasize this, a basic peremptory norm of customary law. The text is, the territory of a state shall not be the object of acquisition by another state resulting from the threat or use of force. No territorial acquisition resulting from that threat or use of force shall be recognized as legal. Starting 27 February 2014, the Russian military presence was increased without Ukrainian consent. The Ukrainian authorities were displaced by the Russian military. New local authorities were established. A referendum declaring the secession of Crimea was held, and on 18 March, a treaty of unification was signed. These developments took place without the consent and against the will of the pre-existing local Ukrainian authorities and of the Ukrainian government. They must therefore be characterized as a use of force. As the referendum was held under the control of new authorities, which had come into power pursuant to this use of force, it cannot be characterized as free and could therefore not constitute a valid exercise of the right to self-determination, even if the population of the Crimea could be considered as a people having such right. By a resolution adopted by an overwhelming majority, the General Assembly in 2014 drew the necessary consequences. It calls upon all states, international organizations, and specialized agencies not to recognize any alteration of the status of the Autonomous Republic of Crimea and the city of Sevastopol on the basis of the above-mentioned referendum. Indeed, only a handful of states have recognized the change. Thus, the attempted territorial change has failed as a matter of law. The Crimea Peninsula has remained Ukrainian territory. This has consequences under the law of state responsibility and concerning the status of the territory, which determines applicable law. The law of state responsibility imposes a duty on all states to cooperate to bring a violation of a peremptory norm of international law to an end, as well as a duty, just mentioned, not to recognize the result of that violation. What does that mean? States must abstain from any act which could be interpreted as recognition. Let us discuss examples. Question of consular protection. A foreign state cannot effectively exercise consular protection vis-à-vis Ukrainian authorities for a national who happens to be on the Crimea peninsula, as these Ukrainian authorities do no more effectively exercise a control over that territory. But would addressing the Russian authorities who exercise this control for the same purpose constitute a recognition of the territorial change? This is at least the official position of the Foreign Ministry of the Federal Republic of Germany, and I think this is true for many foreign ministries. There are, of course, limits on the principle of non-recognition. In the interest of affected persons, for example, registrations of birth, marriages, and death, they may and must be recognized by third states for the sake of the fate of persons, private persons affected. And that exception has been clearly stated as early as the Namibia advisory opinion of the International Court of Justice. But are negotiations, or is cooperation in the interest of victims of the situation recognition? Not necessarily so, I think. Let me turn to the question of the status. The Russian presence constitutes a non-consented de facto control of a territory by a foreign state. And this is what in international law is called a belligerent occupation. Although there is no more actual fighting, this status continues as long as occupation de facto lasts. This is the result of Article 6 of the Fourth Geneva Convention. Belligerent occupation is a well-defined status under international law. Basic rights of the members of the population and certain interests of the temporarily ousted sovereign are protected. But we have now to address the uncertainty. The practical and legal problems arise from the fact that the Russian Federation denies these consequences. A partial solution of this dilemma, and I think it's necessary to find practical solutions to this dilemma, can only be found in a look on equivalent protections granted by other rules of international law. Let me turn to these equivalent protections. Fundamental rights are guaranteed by the law of occupation in the Hague Regulations and the Fourth Geneva Conventions. These guarantees have a corollary in the extraterritorial application of human rights based on de facto control. This application of human rights law, extraterritorial application of human rights law, is confirmed in the constant jurisprudence of the International Court of Justice and regional human rights courts. Personal freedoms, property are thus protected. That was confirmed by the European Court of Human Rights in relation to the Crimea in a case Ukraine versus Russian Federation. However, loyalty requirements and population transfers, which are prohibited by the law of belligerent occupation, are not prohibited as such by human rights law. Human rights law may nevertheless provide equivalent protections. Important in this respect is what the ICJ held in Ukraine versus Russian Federation, where it recognized that the Tatars and ethnic Ukrainians on the Crimea peninsula are groups protected by the Convention on the Elimination of Racial Discrimination. The merits of the case are still pending, but the court has clearly said that the convention is applicable to the problem, and therefore confirmed the admissibility of the claim. The protection of property brings in the question of protection of investments. The relevant awards are not publicly available, at least not to me, but it appears that arbitral tribunals have applied the Ukrainian-Russian bilateral investment treaty for the protection of Ukrainian investments in the Crimea against expropriation by Russia, apparently on the ground of an extraterritorial application of the BIT based on de facto control, which seems to be an argument similar to the extraterritorial application of human rights. Let me turn to a very difficult question, namely the exploitation of natural resources by the occupying power. This is restricted under the law of occupation, a restriction which does not exist if the transfer were valid. The occupying power is limited to a use of resources according to the principle of usufruct. This means exploitation not exceeding a sustainable yield, for instance, for renewable resources, for renewable biological resources, such as fisheries. While exploitation of non-renewable resources under the regime of occupation is, to say the least, highly problematic. And this applies in particular to oil and gas. Where the resources in question are situated in sea areas, to look for equivalent protections under both regimes requires an analysis of rules on resource management under the law of the sea. In this respect, the Permanent Court of Arbitration, in the framework of the law of the sea dispute settlement system, has accepted jurisdiction, except where its decision requires a determination of the sovereignty over the Crimea. It remains to be seen how far finding equivalent protections is possible without the court pronouncing itself on the question of sovereignty. The exploitation of resources is also a question of the protection of investment, and that brings us back to the question of what happens to licenses given by Ukraine and then expropriated by Russia. So far, an overview which time permits. Let me briefly turn to the procedural issues. Under belligerent occupation, there is no formal remedy. The guardian is the ICRC. Now, it's diplomatically difficult for the ICRC to address the Russian government, saying you're an occupant, knowing very well that this is the end of the story. I'm not teaching diplomacy to the representatives of the ICRC. I turn to the phenomenon of procedural creativity, which we see nowadays. Human rights complaints under the European Convention of Human Rights, arbitration under investment regimes, and law of the sea dispute settlements are avenues which can be used, and this is a very formal aspect of what has been called lawfare. Let me conclude on the question of uncertainty. Yes, there is uncertainty, but the persons affected in one way or the other may ask lawyers for practical solution, and courts, as I see it, are on the way to provide those solutions. Thank you very much.
Thank you very much. Sorry. Thank you very much, Professor Bothe. We will now move on to our next speaker, Dr. Robert Heinsch, who is an associate professor of public international law at the Grotius Center for International Legal Studies at Leiden University, and the director of its Karlshoven-Gieskes Forum on International Humanitarian Law. He is founder of both the Leiden IHL Clinic and the IHL Clinic at Bochum University in Germany. Dr. Heinsch is a member of the German National IHL Committee, and he has held the position of Federal Dissemination Officer for International Humanitarian Law at the German German Red Cross from 2011 to 2014. Previously, he worked as a legal advisor at the Red Cross headquarters in Berlin and as a legal officer in the trial chamber of the ICC. In addition, he has been senior research fellow at Cologne University and a visiting lecturer at Bochum University. Dr. Heinsch will speak about occupation by proxy with a focus on Donbass. Please.
Thanks a lot, Yaël, for the kind introduction, and warm welcome to everyone. And thanks also to the GRC as the organizers for inviting me to talk about this important topic. As Yaël indicated, my topic is occupation by proxy, a focus on Donbass. And I want to divide my presentation into three different sections. I will first start with a short introduction, give a bit of a background why this specific topic is interesting, and also compare it to a presentation I gave 7 years ago at West Point Military Academy, which was not dealing with occupation in the eastern Ukraine, but we were just talking about classification of conflicts. My second part is the main part, and we'll actually look at the fact, do we know and do IHL knows what occupation by proxy is? Do we know this concept? And if yes, how can we deal with it? And I will suggest that we need to approach this on a two-step level or two-step approach. And I will say more about this more in detail during my second part. Last but not least, in my third part, I want to take consequences, find a conclusion for the region of Donbass, and see what the application of this legal concept means if we apply it to the facts. Coming now to my introduction. As I said, 7 years ago, almost 7 years ago, I was asked to speak on a similar occasion. We had an expert meeting at West Point, invited by Mike Schmidt, to talk about the situation in the Ukraine. First of all, on the one hand, I'm happy to pick up on that. On the other hand, I'm very sad that I still have to talk about this because it's 7 years later, which brings us to what something Yaël also meant, the discrepancy maybe between the law and the policy. And we have to ask our questions, how can it be that 7 years later, we still have this conflict? But what has changed and why are we now focusing on occupation? In 2014, the conflict at that point was obviously still fresh and the first hostilities had just occurred. the control over respective territory was far from secured. There was another presentation by my colleague Robin Guys, who talked about what now Michael Bothe was talking about, the occupation or / annexation of Crimea. Today we have a different situation. It is clear that Ukraine does not have control over its complete territory in the Donbas region anymore. The control is now partly exercised by pro-Russian rebel groups. And this is also the new situation indicated by something, by pure numbers, because some 500,000 people in the self-proclaimed Donetsk People's Republic and the Luhansk People's Republic have been issued with Russian passports since fighting broke out in 2014. So, one preliminary remark. Since the start of the crisis, the characterization of the conflict has been discussed extensively and controversially. I always like to say that it's important to distinguish each situation as such. Even if hostilities are mainly taking place in the territory of one state, that is Ukraine, it is possible that depending on the time and on the location, we reach different conclusions with regard to the characterization of the conflict. So keep in mind, as the ISTY, the Yugoslavia Tribunal in Tadic stated, there's the possibility that in some areas there's an international armed conflict, including a situation of belligerent occupation. And in other areas, there might be a non-international armed conflict, and maybe in still others, there is no armed conflict at all. So focusing on the law of belligerent occupation could, however, with regard to Eastern Ukraine, to the Donbas region, could bring a special advantage for the affected population. Since the Fourth Geneva Convention offers much more protection to civilians in the hand of an occupying party than general international humanitarian law. It's just a vast, bigger amount of rules which are applicable. In addition, it creates a wide range of responsibilities for the occupying power, which is seen as a de facto administrative authority that has only a temporary right, but also has the duty, for example, to maintain public order and safety in accordance with the local laws in force, which includes the prohibition to change the social, democratic, geographical, political, or economic order of the territory. So overall, the characterization of a conflict situation as occupation in the Donbas region would make it more difficult for the occupying power to change the original situation, that's important, and otherwise also would lead to more possible violations of IHL, and therefore the option to prosecute these as war crimes. So that might be also becoming more important in panels which we have later during those 3 days. So occupation by proxy, does it exist? And if yes, how can we deal with it? So this brings us to an important question. Do we have a situation of belligerent occupation in the Donbas region? Michael Bothe, Wayne George already mentioned that international institutions have been quite reluctant, apart from the Council of Europe, with regard to determining whether this is a situation of occupation. First of all, the background of that is clear. We cannot lightly assume that the classical situation of belligerent occupation of one state occupying a part of another state is fulfilled, despite obviously heavy Russian involvement. This is, for example, demonstrated by the UN General Assembly Resolution A73 from 2018, which only, in quotation marks I want to say, designated Crimea as under temporary occupation. Both Article 42 of the Hague Regulations, as well as Article 2 of Geneva Convention number 4, seems to presuppose that a regular army of another state is taking over control of the respective territory. However, and that's important always to look at the text of the respective provisions, both regulations don't mention the word state, but talk about the hostile army and partial or total occupation of the territory of a high contracting party without indicating the state-like character of the occupier. Given the fact that both the 1907 Hague Regulations and the 1949 Geneva Conventions number 4 were designed for international conflicts between states, it is clear that the respective drafters originally did not foresee a so-called occupation by proxy. Nevertheless, it's interesting to note that in contrast to this, Article 1, Paragraph 1 of Additional Protocol 2 speaks of organized armed groups which exercise such control over a part of its territory, so at least acknowledging the possibility of a non-state actor having effective control over a certain region in which the conflict takes place. However, the term occupation is neither mentioned in Common Article 3 of the Geneva Conventions or Additional Protocol 2, which both primarily deal with non-international armed conflicts. But since these rules and provisions, the Hague Regulations and the Geneva Conventions were drafted in 1907 and 1949, it seems to be obvious that we need to transfer these provisions into modern times. And both academics as well as international tribunals have tried to adapt these respective provisions to modern situations of warfare. Possibility, and now in the middle of my second part, the question, how do we deal with this today, this concept of occupation by proxy? Possibility of the existence of an occupation by proxy was actually hinted at, and I call it hinted and not confirmed, by the 1997 ISTY Tadic trial judgment, the 2000 Blaskic trial judgment, as well as the 2003 Nateljic trial judgment. Sorry for my pronunciation, I'm really bad at this. The latter's approach being confirmed by the 2013 Pirlich trial judgment. So we have like 4 trial chambers who somehow assumed or dealt with the fact how it is if a third outside state, back then Serbia or Croatia, was having influence on non-state armed actors and dealt with this concept of occupation by proxies. However, we need to take into account that these were trial chambers and was never confirmed on the highest level, the appeals chamber, whether this exists. And that also led to the fact that these trial chambers partly contradicted each other. However, in 1999, the Tadic appeals chamber had opened the door for so-called internationalized armed conflicts in general, using this famous concept of overall control over a non-state armed actor. And this leaves us with the problem of what are the components of this occupation by proxy or indirect occupation. And so I'm now going to suggest the most sensible approach, which has also been confirmed by important actors. And yeah, I know I'm almost running out of the 10 minutes time. I will take another 2 or 3 minutes. I'm very sorry for that. My watch says I have 30 seconds left, but I need a little bit more. I will make a case that the most sensible approach lies in the combination of the approach of the Nateljic trial chamber and the Tadic appeals chamber, which requires A, effective control of the non-state actor over the respective territory. So that's the first step. And B, the overall control of the third state over the non-state actor organized armed group. And that should not be confused with each other. This takes into account the explicit wording and majority view with regard to the requirement for establishing belligerent occupation as reflected in Article 42 of the Hague Regulations, which reads, territory is considered occupied when it's actually placed under the authority of the hostile army. The occupation extends only to the territory where such authority has been established and can be exercised. And this has been confirmed, the possibility and the double approach of these 2 steps has been confirmed by my colleague Niels Melzer in his textbook on IHL, which is published by the ICSC, by the way, where he says effective control does not necessarily have to be exercised directly through the armed forces of the occupying power. Belligerent occupation can also exist when the foreign state exerts overall control over local authorities who in turn exercise the direct governmental control as the de facto state agents on behalf of the occupying power. And he is referring to the respective ISTY jurisprudence. And we also have an indication that even the drafters of the Geneva Conventions in Article 29 thought about this in some way, because they're talking about responsibility for the agents of the occupying power. So that can be a non-state actor. Whether an occupying power exercises effective control depends, on the other hand, on the conflict's party factual ability to assume the de facto governmental functions of an occupying power, and most notable, to ensure public security as well as law and order, and not by its mere willingness to do so. And the ISTY has also elaborated on this, and I will, however, now not go into the detail, leave that maybe for the discussion. Let me now come to the second requirement and then come to a conclusion very quickly. If we come to the second requirement for occupation by proxies, it's the level of control exercised by the third state. I believe that by now the approach of the 1999 ICTY Appeals Chamber for the question of internalization of non-international conflicts in the context of the actions of an organized armed groups are to be seen as having overall control, completely being aware that there is a discrepancy and a tension with regard to the jurisprudence of the ICJ, especially when it comes to state responsibility. But this overall control standard has not been only consistent jurisprudence of the ICTY Appeals Chamber, but also has been taken over by other courts and tribunals, including the International Criminal Court. So in that context, I believe the solution is this double approach to have effective control by the non-state actor as an agent and as the representative of the third state, the outside state, exercising overall control. What does this mean for the Donbass region? Very briefly, this could possibly be acknowledged that if we come to the conclusion that pro-Russian rebel groups exercise effective control over the territory in Donbass, and at the same time, Russia would have overall control over these organized armed groups. Is this the case? I want to say most likely, knowing the facts, certain public available facts and assumptions are pointing towards this. However, can I prove this at the moment? I think probably not. And I've written also a long article on this where I'm dealing with this. The problem is always that in the moment, if we don't have a tribunal having the possibilities to do investigations, it always comes to the indication of what do we have there which could prove that there's overall control. And Russia is very often denying its influence or involvement. So we need, it's dependent on these details. So this makes it problematic, but I'm sure there are very many learned colleagues in the room, in the virtual room here, who might also be able to give additional factual background. So this concludes my presentation on the concept of occupation by proxy, which I believe is clear it exists. There are strong signs that we have such a situation in the eastern Ukraine. I thank you for your attention, and I'm happy to answer questions after the fourth colleague has presented. Thanks a lot, Yaël, for giving me a couple of minutes more.
Thank you, Robert. And before we move on to our next participant, let me just remind the speakers of what I always have to remind myself. Don't speak faster only because we're running, if we're running out of time, we do have interpretation here and we do want the audience to be able to follow us. With that in mind, let me introduce our third speaker, Max du Plessis. Max du Plessis is an advocate, senior counsel in South Africa, an adjunct professor at the Nelson Mandela University, an honorary research fellow, University of KwaZulu-Natal in Durban, and a senior research associate at the Institute for Security Studies in Pretoria. Abroad, Dr. du Plessis is an associate tenant at Doughty Street Chambers, London, and an associate fellow at Chatham House. In South Africa, he has appeared in leading cases on international law and human rights law in the Constitutional Court and the Supreme Court of Appeals and the High Courts of South Africa. He has also appeared or consulted before the African Commission on Human Rights and People's Rights, the SADC Tribunal, and the Human Rights Committee. He's acted as advisor to governments and NGOs on questions of an international law. As an international criminal lawyer, Dr. du Plessis has advised states before the ICC and has been working on domestic cases dealing with arrest warrants for senior government in various states in Africa. He has published extensively on international criminal law topics and is a frequent panelist at conferences and events around the world. Dr. du Plessis will discuss the question of lawful secession through self-determination. Please, Max, the floor is yours.
Thank you very much, Yaël. Morning, everybody. I will be speaking on the lawful secession through self-determination. And as I understand it, I'm meant briefly in 10 minutes to sketch the general landscape without necessarily coming to any conclusions, which is just as well. Sir Robert Jennings, a former president of the International Court of Justice, said there's a tendency for international lawyers to keep away from black holes in the system, where the basic assumptions and even the policies of the law have parted from reality. Well, I'd like to perhaps controversially suggest that some states, including Russia, may well wish for the Crimean situation to neatly fall into that black hole. But as I briefly show, there are international law principles that can be drawn together here. And as Wayne Jordas said in his opening remarks, warfare needs to be met by lawfare. And the aim, I think, of our very conference is to avoid black holes. There are examples of successful secessions since 1945 and outside the process of decolonialization, we know that, and which support the existence of the right of a people within a territory that doesn't represent the population of the territory as a whole to secede from that territory. The examples are the Bengali people seceding from Pakistan, the South Sudanese seceding from Sudan, and of course the Albanian people of Kosovo seceding from Serbia in 2008. And the bid by Kosovo for independent statehood, as we all know, ended up at the International Court of Justice. And international lawyers had hoped that the court would set out clearly the legal parameters of secession, but frustratingly, the ICJ's Kosovo's advisory opinion did not address the question of the existence of a right to remedial secession. The ICJ noted that differences existed regarding whether international law provides for such a right of remedial secession, and if so, in what circumstances. But it ducked the overall issue. It ultimately held that it wasn't necessary to resolve those questions in that case. Still, and I'd like to stress the still, two judges in the case did go on to consider whether a right to remedial secession existed in separate opinions. So Judge Concado Trinitado's view was that the government of a state which incurs grave and systematic violations of human rights ceases to represent the people or the population victimized. And he then said that a claim to territorial integrity could no longer be invoked by the rights violating state. Judge Trinidado drew upon the text of Principle 5 of the United Nations Declaration on Friendly Relations to argue that the principle of respect for the territorial integrity of states only applies to those states that are conducting themselves in compliance with the principle of equal rights and self-determinations of peoples, as described in that declaration. And in his separate opinion, Judge Yusuf agreed that the declaration is not exclusively or only there to protect territorial integrity and national unity. According to Judge Yusuf, the right of a people to remedial succession may be invoked in exceptional situations where the people have been denied the right to internal self-determination and there's been a massive violation of human rights. So to step away from that, we can see that openings for secession exist, but that they are very tightly drawn. The circumstances in which remedial secession, in other words, secession exercised in light of a denial of the right to self-determination, or what is sometimes known as external self-determination, may be accepted as a legitimate exercise of the right to self-determination, but is confined to these critically small situations where the people concerned have been denied the right to internal self-determination and have been subject to grave and systematic violations of human rights and persecution. So that allows us to then move to post-Kosovo developments. The failure of the ICJ to provide guidance on the law governing secession and the relative success of Kosovo in its bid for independent statehood. Remember that it was recognized by 117 states thereafter, despite its non-admission to the United Nations. Well, all of that has inevitably resulted in demands for statehood by other entities. The will of a people to exercise self-determination is obviously most clearly expressed in a referendum. And we've seen in recent times how referenda have been used to test public opinion on secession in Scotland, in the Kurdish autonomous region in Iraq, and Catalonian demands for independence from Spain, and more catastrophically in respect of Brexit, but which is a conference all on its own. But all of these attempted secessions have involved historical and cultural groups with a distinct identity living in a separate territory, claiming a right of self-determination. In none of the societies in question, however, has the central government denied internal self-determination or suppressed human rights to such an extent that the right of remedial secession became a possibility. And critically, those referenda have not been compromised by a parallel annexation through the use of force by an outside state. That's why the secession of Crimea from Ukraine in 2014 and its subsequent annexation by Russia is far more complicated. We know the history. Crimea was part of Russia until Khrushchev awarded it in 1954 to Ukraine as a token of friendship. We know that Crimea then became an autonomous region within Ukraine after the dissolution of the USSR, but with a largely Russian population. And we know too that in 2014, when Ukraine broke its ties with Russia and became pro-European, that Russian troops were immediately deployed to and within Crimea. We know as well that a referendum was held in Crimea, in which 95% of the population apparently supported independence from Ukraine and the annexation of Crimea by Russia, which followed shortly thereafter. And the presence of Russian troops, we know, was a factor in this process. And critically, the Security Council, however, was unable to pronounce on the annexation due to the Russian veto, although the General Assembly did condemn it as a territorial violation of the territorial integrity of Ukraine. So, to step away, the decision to secede from Ukraine and to seek incorporation within Russia was the result of a compromised referendum in a territory historically closer to Russia than Ukraine, in which a majority consisting of mainly ethnic Russians voted in favor of secession. On the other hand, the circumstances did not warrant remedial secession, most obviously because there was no grave and systematic violation of human rights and persecution of Russians within the Ukraine. And as we know, the right to remedial secession or external self-determination is extremely limited. You don't have to believe me, you can believe Russia. In the course of the Kosovo proceedings before the ICJ, Russia was very wary at that time, you might remember, of Chechnya's request for independence. And so Russia issued a written statement during the Kosovo proceedings before the ICJ, in which it recorded its position very clearly, and I quote it: "The right to external self-determination," said Russia, "should be limited to truly extreme circumstances, such as an outright armed attack by the parent state threatening the very existence of the people in question." Those words, of course, should be applied to Russia, not only when it serves its interests, but outside of the Chechen context as well. Perhaps most importantly, to problematize matters further, the Russian military's deployment in Crimea constituted a violation of the territorial integrity of the Ukraine, which was condemned by the General Assembly, and arguably the annexation was invalid for violating a peremptory norm, as Professor Bothe has aptly already described to us. And so now that territory is under what is called temporary occupation, but it remains de jure Ukrainian territory. These complicating factors allow me to conclude. As the Canadian Supreme Court put it in the Quebec secession case, international law contains neither a right of unilateral secession nor the explicit denial of such a right. It's clear, I think, that secession is governed by rules of international law and that these rules guide states in their decision whether to recognize an entity claiming to be a state. But as the debates in this conference attest, the right of self-determination and the principle of territorial integrity, while still both significant principles, are increasingly subject to contestation and qualification. It's the task, I think, of states and international institutions and of ourselves in conferences like these to balance these rights wisely to ensure fairness and stability in the international legal order, and to do so with a very clear recognition that there are forces afoot that are attempting to use their power in ways which ultimately are there to destabilize the international institutions and international rules that are applicable and which make for civilized and peaceful existence together. There can be few examples where that is happening, I think, more forcibly than in the context of Crimea and Russia in the background. Thank you very much.
Thank you very much, Max. And without further delay, let me introduce our fourth speaker, Dr. Sandra Krahenmann. Dr. Krahenmann holds a PhD from the Graduate Institute of International Studies in Geneva, and she teaches at the Geneva Academy of International Humanitarian Law and Human Rights for the Masters in Transitional Justice and Executive Masters in International Humanitarian Law. Dr. Krahenmann's research over recent years focuses on the impact of counterterrorism on human rights law and international humanitarian law, with a particular focus on measures to stem the so-called foreign fighter phenomenon. as well as on the application of human rights during times of armed conflict. And she has written a series of articles on these topics. Dr. Krahenmann will speak about the relationship between counterterrorism and international humanitarian law. Please, the microphone is yours.
Well, thank you very much for the kind introduction. Thank you for the organizers for having organized this conference. So I've prepared a short presentation just also for the ease of audience to follow. So I'm going to share my screen now, which after all of these years, we still have troubles doing. So I'm going to switch a little bit gear now. The previous co-panelists, they have spoken very much about questions of status and conflict qualification and what may be applicable or not. I want to focus more on applicability of law. I think regardless of how we qualify the situation, when we speak about an armed conflict, then, we imply that international humanitarian law applies. And this has indeed been raised by many speakers who spoke about different aspects of international humanitarian law. But what we also see is that in practice, in many of these instances, when there is an armed conflict and international humanitarian law applies, there is a tendency also to resort to another legal regime, the legal regime governing terrorism, which intuitively makes sense because they both address acts of violence. But they address different forms of violence and they're regulated differently. So in my presentation, I want to speak a little bit about how international humanitarian law interacts with the legal regime governing terrorism. And to do that, I'm afraid I need to take a step back and speak first a little bit about what is this actually when we say the international legal regime governing terrorism. How does that legal regime govern or organizes its relationship with armed conflict? And then what does actually also the other side, international humanitarian law, have to say about acts of terrorism in times of an armed conflict? So if we say there is an international legal regime governing terrorism, this is actually it's not a unitary regime. It's not like IHL that we can find neatly in the Geneva Conventions and the additional protocols, but it's spread out over various branches of international law. So I want to focus on what I sometimes call the two pillars. On the one hand, we have international treaties that address specific acts of terrorism. And then during the last 20 years, we have seen that the Security Council has actually been very active in developing the regime governing counterterrorism. If we look at the international treaties on a universal level, we have what we would call the sectoral approach, where we have 19 universal treaties that address specific acts of terrorism. So, for example, you have a UN Convention on the Financing of Terrorism, you have one on the terrorist bombings, and so on. These treaties, they define the act, and then they organize the criminal repression of such acts with the idea that perpetrators of terrorism should not be able to find a safe haven somewhere else just because of questions of jurisdiction or lack of extradition. As I've said, there are 19 universal treaties. They all address specific acts of terrorism, which also shows you that we do not have a comprehensive universal treaty. So there's no treaty on acts of terrorism per se. There have been ongoing negotiations for the last 20 years to have such a comprehensive treaty be for the 6th Committee of the General Assembly, but it's not advancing. And there are significant obstacles in trying to find an agreement about how to define terrorism. One of these obstacles is precisely also the question of how that would relate to armed conflicts, including also the acts of national liberation movements. On a regional level, states have been able to overcome this to some extent, where we can find a general treaties on terrorism, and you see two examples on your screen, where they have either agreed on a common definition or some of these treaties also just take the terrorist offenses in the UN conventions and then apply a more general regime to them. As for every other treaty, this of course only applies when states have ratified the treaties. And this is where the Security Council comes in the sense that in the aftermath of 9/11, the Security Council has adopted Resolution 1373 on terrorist financing, where in a nutshell, it took the obligations from the UN Convention on Terrorist Financing and integrated them into the Security Council resolution adopted through Chapter 7, and so made it binding for every state, even those who were not a party to the UN Convention. This has then been repeated on terrorist financing with a more recent resolution, 2462. And another resolution that the Security Council has adopted is 2178, which was adopted against the background of the so-called foreign fighter phenomenon, where the Security Council requested states to make sure that traveling abroad for terrorist purposes is a criminal offense and can be prosecuted as such. So all of these resolutions speak about, financing of terrorism or travel with terrorist purpose, but they do not define terrorism. So it's basically left to the implementing individual member states to define terrorism in their own national legislation, which then of course will depend the scope given to these resolutions in practice. Another pillar of the Security Council framework that I'm not going to talk about too much is the sanctions regime. As you know, we have country-specific sanctions, and then we have the sanctions regime for Daesh and Al-Qaeda and groups associated with them, which is what we commonly call the terrorist sanctions regimes. There are two things I want to flag with this regime so this takes a law enforcement approach. An act of terrorism is a crime that needs to be investigated and prosecuted. And it's also a question of individual perpetrators and individual criminal responsibility. There is an open question about whether there can be something such as state terrorism. It's one of the obstacles we also face when we're trying to conceptualize a comprehensive universal treaty. It was also one of the questions that came for the universal treaties, in particular the Convention on Financing of Terrorism, where there was a question that was addressed by the International Court of Justice in the preliminary objections phase in the case between Ukraine and Russia, where there was a question whether the convention also criminalizes a state financing terrorism, or whether then there can be state responsibility for the financing of terrorism as such. So the ICJ has clarified that you can have state responsibility when a state fails to prevent and suppress the financing of terrorism, but under the convention, so not necessarily under general international law, but under the convention, it is not state responsibility for financing of terrorism per se. So that's also like a limitation in terms of the personal scope of these conventions. So I've said how we do not have a comprehensive universal treaty, amongst others, because we cannot agree on how this would relate to armed conflict. And now you may think, well, but how do the sectoral treaties, how do they address this relationship? So I wanted to give you two examples of how they do that. So you have, for example, in the Convention Against Terrorist Financing, which in its definition of what is an act of terrorism, because when you want to criminalize the financing, you need to define terrorism, you can find like a reference to IHL in the sense that it includes deliberate attacks against civilians or harm to civilians, or the people who do not take an active part in hostilities. So that clearly comes from IHL. And it also has a more general safeguarding clause that nothing in this convention will affect rights, obligations, and responsibilities of states and individuals under international law, including international humanitarian law. The Terrorist Bombing Convention has a much more explicit safeguarding clause that we can also find in the Regional Convention of the Council of Europe, where it specifies that the activities of armed forces during an armed conflict as those terms are understood in international humanitarian law and which are governed by that law, they are not governed by this convention. So if we're trying to think now about the relationship, we can see that the international treaties, they have these safeguarding or exclusion clauses, where there can be a discussion about the scope and how we can operationalize those. But there is a trend to exclude situations of armed conflict governed by IHL. The Security Council in its resolution sometimes make a generic reference that, this needs to be in compliance with IHL, but there is no guidance given on what this actually means and implies and how we can ensure that. National legislation sometimes do, but quite often do not have such exclusion clauses. The problem we then see is when you conflate terrorism with armed conflicts, this can have important humanitarian consequences. And I just want you to flag a few of them. On the one hand, humanitarian organizations have been flagging for a long time that this can potentially criminalize humanitarian activities. So if you deliver humanitarian assistance in an area where you have designated terrorist groups, this may be criminalized, for example, as providing support to such groups. Importantly also, it can criminalize everyday activities of civilians in areas where designated terrorist groups operate or control the territory. So the paying of taxes, for example, can be considered terrorist financing if it is to a group or an organization that is considered terrorist by one of the sides to the armed forces. So civilians quite often also find them squeezed between different parties to the conflict, that they will always consider the other party also be a terrorist actors. We also know that in quite a few armed conflicts, it then also means when the state no longer controls all of its territory and the state considers that there are terrorist entities present in the territory, it will no longer finance critical services in such areas. So for example, teacher salaries. Suddenly nobody will pay a teacher's salary, then who is going to provide education? From a broader policy perspective, it makes also peace negotiations very difficult from both a legal, also from a legal perspective. We all know that you do not negotiate with terrorists, and it's not something that is foreseen for under the terrorist regime. So you may now think, okay, so we have this tension, and it's not just a legal or conceptual tension, but it does have important humanitarian consequences in practice, in particular for the civilian population affected. And how can we resolve that? Well, one way to resolve that is precisely by resorting also to IHL, which is the legal regime that is specifically designed to apply in times of armed conflict. And contrary to what people sometimes assume, IHL actually is equipped and acknowledges that there can be acts of terrorism in times of armed conflict. And this is what I want to conclude with. I think a first important consideration is that the designation of a group or any other party involved in an armed conflict doesn't affect the applicability of IHL. IHL affects when the criteria for conflict qualification, when they are met, as has been explained by the previous panelists. The second aspect is that IHL, it comprehensively prohibits any act that we would ordinarily label as terrorism. Either generically, so, if you take, for example, hostage taking or attacks against civilians, all of this is prohibited under IHL. But there are also specific IHL rules that address terrorism, and you have namely two different kinds of rules. On the one hand, you have a prohibition of terrorism against the civilian population under the control of one of the belligerent parties. And on the other hand, you also have a specific prohibition of attacks or threats of attacks with the primary purpose to spread terror. And then finally, and most importantly, also IHL organizes the repression of such acts as war crimes. And we have some precedents in international criminal law. One of them would be the case of General Galic before the International Criminal Tribunal for the former Yugoslavia, who was convicted for an attack with the primary purpose to spread terror due to the campaign of sniping and shelling that was targeted civilians during the siege of Sarajevo. So I would say that we have seen important humanitarian consequences when you conflate the two regimes. And if you look at how IHL addresses acts of terrorism in times of armed conflict, you don't really gain a lot by conflating the two regimes. And then you need to think about what are the humanitarian consequences that follow from that. Thank you.
Thank you very much, Sandra. Since we have run a little bit out of time, the organizers have decided that we're just going to go through we'll continue during the coffee break, and then we'll go directly on to the second panel, so that we will have a little longer now for the questions and answers session. So we do have questions for all 4 participants, and let me just in order to let Sandra have a moment to think, I think some of the earlier speakers know what the questions are, that some of the questions are that have been addressed to them. So let me just start with a few of them, and then maybe we'll take a second round. So for Professor Bothe, one question from Mykola Gnatovsky is about the reference to the ICRC as the guardian of IHL, which is for diplomatic reasons unable to raise the applicable provisions of IHL with the occupying power, namely Russia. So the question is whether you consider this to be the end of the story, namely that the applicable law cannot be applied, so one would have to look to other applicable rules of international law that offer similar protections. And the question is whether it's this easy to dismiss the applicable legal regime by means, easy for Russia, simply by means of outright refusal to apply it. One question for Dr. Heinsch is, what are the indicators for determining whether a state has overall control over a group? That's a question from Manu Gillard. To Dr. du Plessis, a question on the matter of lawful secession from Charles Chamath. And the question is whether Article 8 of the 4th Geneva Convention, which states the non-derogability of the rights of protected persons, whether that implicitly precludes the possibility of recognizing a claim of lawful secession based on protected persons' exercise of their right to self-determination in an occupied territory, when that would nullify the applicability of the convention and their rights to its protection. And finally, to Dr. Krahenmann, a question whether the Ukraine was strategically right in invoking the Terrorism Financing Convention as the legal basis for the ICJ proceedings, considering that there is an ongoing armed conflict in eastern Ukraine. Russia argues that IHL and terrorism suppression regimes are mutually exclusive. So what is your view on this? So if I could ask each of the speakers to respond to the question, and maybe to the other speakers if there's something that you'd like to raise, and then hopefully we will have time for another round of questions. Thank you. And can I just suggest for the sake of good order, let's start with Professor Bothe.
Well, thank you. And I put the case in my intervention, my contribution, just provoking that very question which has been asked. It's bad diplomacy if one actor tells the other, you're a bad guy, therefore you have to behave. And the ICRC is more sophisticated than that. Now, it's for sure that if the ICRC would just plead the law of belligerent occupation, it could not get very far in the negotiations with Russia, negotiations concerning the fate of members of the population, because that is the essential point here. Now, there is what the ICRC has called, and what is now an accepted term in international law, the right of initiative of the ICSC. And you do not find that clearly in the Geneva Conventions, but it is, I think, and many agree, well established under customary law. And that goes far beyond situations to which international humanitarian law is technically applicable. It has been used in the early days of the Cold War for visits of political prisoners. Whether the prisoners were political could have been left open, but the basic idea was that the prisoners, persons present in some jails around the world and mainly in Europe, had something to do with the political situation. That was a very effective and useful initiative of the ICSC. And this is a basis, this right of initiative, which could be used by the ICSC without claiming the law of belligerent occupation is applicable. But it would provide what I have called equivalent protections. I think this is practically important. So in this way, the ICSC is a kind of de facto guardian without claiming to be a de jure guardian of international humanitarian law. Thank you.
Thank you. Let's move on to the second question to Robert Heinsch.
Yes, thanks a lot. Thanks, Emanuela, for the question about the indicators for determining whether a state has overall control over a group. I want to say it's nice to see you again, but I don't see you because last time we saw each other was at an IHL clinic exchange conference in Rome. So hello, good to see you. But coming to this question, and I'm happy that you asked this question because I had it in my presentation, but I cut it out because due to time limits and I didn't want to offend anyone. So quoting from the ICTY jurisprudence, the overall control test in the most general term says that it must be proof that the state wields overall control over the group, not only by equipping and financing the group. So that means just paying the group or giving weapons, etc., is not enough, but also by coordinating or helping in the general planning of its military activity. So the key is the general planning of the military activity that would require that certain Russian representatives, government officials, military commanders are in connection with the rebel groups in the region and are giving general planning, but, and that is the second part of the quote, however, it's not necessary that in addition, the state should also issue either to the head or to members of the group instructions for the commission of specific acts contrary to international law. So what is not necessary is to give specific details on what the rebel groups are supposed to do, saying like you have to blow up that building or attack the enemy at that time on that day with these kinds of weapons. So that would be what the ICJ would require for effective control. So in the end, the ICTY is having like a broader approach, which, as I said, I believe has been accepted by the international community and by international courts and tribunals when we talk about the internationalization of NIACs. So, and that brings me, and I'm looking at Yaël, whether I have a question to time to answer the question by Ariq on the question whether this makes now a difference between whether it's just an internationalized NIAC or an occupation by proxy, because in some ways the standard seems to be the same. Can I say 2 sentences on this?
Yes, go Yeah, go ahead, and then we'll let the others
Okay.
we'll add other questions later.
So the question was, how do you think about the relationship between the internationalization of NIHC and the occupation by proxy? If we can simply apply the overall control test to the problem of occupation by proxy, that is the required relationship between the intervening state and the non-state armed group, which control the concerned territory, the issue is not so unique. And there's much more, and I don't go in all to the details. I want to say it's still unique because the difference is that the non-state armed actor needs to have effective control over the territory. So it needs to have actually the access and the possibility to exercise normal administrative and governmental functions. And that's something which some people are already questioning, whether actually non-state armed actors are actually able to do that in the same way as government forces. And so in that regard, what I said at the beginning and what I'm emphasizing is this two-step approach makes it so unique because it raises in the end the requirement on one level, namely the control over the territory to the effective control, while the influence of the third state is only overall control. So the combination makes it unique, and it also makes it unique in a way that obviously once we say law of belligerent occupation GC4 is applicable, we have a much more elaborate set of rules applicable to the situation, which, as we will learn in the coming days, might also give us access to much more possible violations of the occupying force. So happy to discuss this maybe bilaterally, but I don't want to take more time from my other colleagues. So thanks a lot for the questions.
Thank you, Robert. Just before we move on to Max, which is on my screen, your picture is completely frozen. I hope you're with us. Max? Oh, okay, you're there. Okay.
I'm here.
So let me just before I let you answer the question, there was a question from Charles Shamus about the relationship between the right to about a lawful secession and the non-derogability of the Geneva Convention. Let me just add another question that has arisen is, what role, if any, does the Security Council play in the context of secession and self-determination? For example, would it have made a difference if the Security Council had condemned Russia's annexation of Crimea? And also, specifically with regard to the Ukraine, when you discuss the integrity of the referendum and the preconditions for remedial secession, are you by implication saying that you do consider the population of Crimea to be a people?
Thank you very much. And thank you for the question, Charles. It's an interesting one. Certainly, your reference to Article 8 of the Geneva Conventions. And indeed, it's true. I mean, protected persons may in no circumstances renounce in part or in entirety the rights that are secured to them by the present convention. Well, that's so, but quite aside from those rights, of course, there is the inalienable right, the fundamental right to self-determination that exists for people and which is not in any manner or shape or form undermined by the fact that they have been occupied. So an occupying power does not by occupation get to override the rights of those that they occupy, not least of all their most fundamental rights to self-determination. And so I would agree with you that implicitly that would preclude the possibility of trying to certainly denounce anybody's rights to continue to claim their rights to self-determination simply because they've been occupied. The other question that I think Yaël has asked is around the role of the Security Council and if it plays any role in the context of secession and self-determination. As I said in my talk, one of the complicating factors in Crimea's succession is the argument that Russia's deployment of military in Crimea constituted a violation of territorial integrity of the Ukraine. And that's so certainly within the meaning of the concept as defined by the ICJ in its Kosovo opinion. So given that Russia's intervention was forcible, arguably the annexation itself was invalid for violation of a peremptory norm. And we know that no right may arise from a wrong. And it follows that the title was acquired by the use of force would then also no longer be recognized. And we've seen that. And interestingly, we've seen that very forcibly through the Security Council's non-recognition of Israel's purported annexation of the Golan Heights and East Jerusalem. And we've seen it as well in the General Assembly's resolution calling upon states not to recognize a change of status on the territory of Crimea following the annexation by Russia. But there's obviously a difference, which is that unlike Israel's annexation of East Jerusalem and the Golan Heights, that had been condemned as illegal by the Security Council. But the annexation of Crimea has been condemned only by the General Assembly, which arguably weakens the case against Russia. But we know why it's not been condemned by the Security Council, and that's because of Russia's ability to use its powers on the Security Council. And to me, that is critically important because it demonstrates in this particular context the very worrying ability of a permanent member of the Security Council being enabled to both assert an act of annexation on the part of a territory of another state, and then to protect itself from any condemnation thereof. And I think that has to be resisted, for else we would have a very dangerous precedent allowing President Putin to continue turning his Soviet Union fondness into action. And I think we've got to recognize that this is a resistance that's required because of multiple failures of the work of the Security Council. It's not only in respect of the Crimea context, it's in respect of what we now know will be the impossibility of getting the Security Council to make any interventions of any assistance in respect of what's happened in Belarus, again, because Russia would be able to veto. And we've seen in multiple ways that the Security Council is an institution which has the power to issue very forceful condemnations and which would then otherwise have had the effects, as we've seen in respect of Israel, not being permitted to get away with the annexation of what has happened in East Jerusalem. Yet in other contexts, the Security Council being abused and its forceful power not being used in a manner which it should be. So I think this demonstrates for me the purposes for debate of precisely where the Security Council's role should be in this context. Should we not actually be moving all our focus towards the General Assembly? And should the General Assembly not be the better means by which we more democratically recognize the means by which the international community accepts and recognizes these types of events? Then there was a final question about whether the peoples can properly be recognized as a people within the Crimea as Russian. I think there's a lot been written about that. I think there are numbers of debates about it. I don't think we have the time to go into it, but certainly it is one of the points, because unless they can be shown to be a people in an homogeneous fashion for purposes of self-determination, that in and of itself would be something to consider. It's certainly a legal element for purposes of the debates around self-determination, and it also requires, I think, a proper analysis.
Yes. Okay. Just before we move on to the questions to Sandra, just a follow-up on part of a follow-up on the last issue of the Security Council, lack of hypothetical resolution. Mykola Gnatovsky asked if, in light of the Chagos opinion and previous ICJ opinions, shouldn't we consider the General Assembly to be the competent UN organ to deal with self-determination rather than the Security Council?
I would emphatically agree.
Okay, that was a quick one. Okay, so let's move on to Sandra with, again, the question related to the reliance on the Terrorism Financing Convention as the legal basis for the ICJ proceedings. And let me just add another question, which is the anti-terrorism conventions deal with international terrorism. And I wonder how your analysis would work if we look at the situation as a non-international armed conflict or situation. Would that simply exclude the issue of terrorism altogether? Or would there still be an issue of a relationship between anti-terrorism or counter-terrorism law and IHL? Please, Sandra.
Well, thank you for the question, Irina. It's an interesting one, but I think we need to take a step back, because we have been speaking a lot about lawfare now, and that there needs to be a role for the law in addressing and dealing with that kind of situations. And then you can do what we are doing here now, where you interpret and you look at what does the law actually say. But then on the other hand, and that's what Ukraine has been doing, you also try a way to implement the law. And of course, one of the obvious ways to go about this is by bringing a case before the International Court of Justice. But then when you do that, you're also constrained by the inherent limitations that we still have in the international legal system when it comes to the judicial resolution of disputes, where you don't have an option of to say which is the best case under which convention, and then we can go to the ICJ, because you need to find a basis for jurisdiction for the ICJ, no? And then I think you look at what is available, and one of the conventions that was available was the Terrorist Financing Convention, and then also third, the Convention on the Elimination of Racial Discrimination. So it's one of the possibilities that you have. You don't have the possibility in the Geneva Conventions or the additional protocols. They do not have a compromissory clause. So even if you could think, well, this may be the strategically better way, it's not an option that you have, because then you will simply have no jurisdiction. So I think you need to look at what is available and how can you use that for your case. For the second aspect on the mutual exclusiveness, I don't think that any regime is completely mutually exclusive and there's no separate regime, no? They all interact with each other. I think my main point is that there is an overlap between these two legal regimes, and then that overlap needs to be harmonized in a way so that we do not end up undermining one regime over the other. And I think that's particularly the case for international humanitarian law, with its primary purpose of protecting civilians, because we have seen during the last decade how the conflation between the two regimes leads to an increased suffering of the civilian population through various ways and mechanisms. For your question about the international element, I don't think I would link that to the conflict qualification per se, because also, as you know, international humanitarian law has a very particular notion of conflict qualification. Now we have two things. We have international armed conflicts and we have non-international armed conflicts, and they do not necessarily fit with how we look at a conflict. Like colloquially, most non-international armed conflicts today, they have an important international element in one way or the other, with either foreign states intervening with the consent. So it remains a non-international armed conflict. You can have the use of proxy forces. So I would not tie the international element in the terrorist conventions to the conflict qualification, because I think conflict qualification in IHL operates in such a specific way and for such a specific purpose, while the international element for the terrorist convention operates in a different way and for a different purpose, if that makes sense.
Makes sense to me. I hope to the rest of the audience as well. Okay, so thank you all very much. We do have 3 minutes before we need to move on to the next panel that is moderated by Mykola Gnatovsky. And I think one of the perks of doing things on Zoom, we're not actually convened. On the one hand, we don't see each other in a conference room. On the other hand, there's no line when we get our coffee. So let's take the 3 minutes that we have left for a little break, and then we'll reconvene at 11:45 for the next session. And please join me in thanking all our speakers for excellent presentations, our audience for super interesting questions and good answers as well. And thank you again to the organizers. So let's take the break.
Tommy, you can go wild, boy. Shame, boy.
Okay. Hello and good morning or good afternoon or wherever you are. Good time of the day to everyone. I think we can start our second panel of the conference. Let me just be absolutely sure that our most distinguished speakers are already online. Okay. My name is Mykola Gnatovsky. I'm a professor of international law at the University of Kiev and vice president of the Ukrainian Association of International Law. And I'm delighted to be moderating this second panel of our conference. And I would like to thank very much Global Rights Compliance and also those who have supported this conference for organizing it. It is really an extremely rich event, and I'm most delighted to be with you. We have now in front of us a panel which will deal with belligerents occupations under international humanitarian law and international human rights law in practice. And this should, of course, be the logical continuation of the previous panel, which was extremely rich and thought-provoking. And I would say it left many more questions open than actually answered in any way. Now we will, as you can already see from the program, we'll first have a more general introduction, placing us in context concerning the interaction between international humanitarian law and international human rights law in armed conflict. And then we will spotlight three different topics. Well, they're rather interrelated, I would say, but they are very concrete, and also to a very significant extent they are in the focus of attention in respect of the armed conflict in the territory of Ukraine, namely the obligations of the parties to the conflict relating to the environment, to water, and to health, especially in the context of the COVID-19 pandemic. Without further ado, let me introduce our first speaker. Once again, I must say, I feel extremely privileged to have such a speaker to open our panel. This is Professor Jann Kleffner, who is a professor of international law at the Swedish Defense Academy and an extraordinary professor at the Faculty of Law of the University of Pretoria in South Africa. And Professor Kleffner, certainly, I don't think he really requires a lot of introduction, because this is a name extremely well known amongst those who deal with human rights law, international humanitarian law in particular, and also international criminal law. He is a well-known expert and consultant for a number of states and also intergovernmental and non-governmental organizations, including the United Nations, the ICSC, International Criminal Courts and Tribunals, and the International Law Association. And he also served for 10 years as head of the Center of International and Operational Law at the Swedish Defense Academy. So Professor Kleffner will speak about the interaction between international human rights law and international humanitarian law in armed conflict. And I think we will follow the same structure as the first panel did. So I would kindly ask our speakers to limit the initial presentation to 10 minutes if possible. And then we will, after everyone has spoken, we will do several rounds of questions. And I immediately invite also all the participants to raise the questions once they arise immediately in the chat. That will facilitate my work very much, and also that will also help our speakers to have a look at which questions are being asked. So, Professor Kleffner, the floor is yours.
Well, thank you very much, Professor Gnatovsky, for your kind introduction, and also to global rights compliance, for the invitation and for putting this conference together. As you already mentioned, Professor Gnatovsky, in my intervention, I will briefly only set out some of the generic notions that pertain to the interaction between the law of armed conflict and international human rights law in armed conflict. And with that, to provide the ground for the more detailed discussions then on the specific issues that were already mentioned, environmental protection, water, and health, that will be addressed by my fellow panelists. And I will then have time only to scratch the surface of some more specific issues that arise in the context of Crimea and Donbass. But I will do that only by way of flagging those issues and raising a few questions rather than delving into an in-depth analysis for obvious reasons of time. Those questions are obviously in no way meant to prejudice any other questions that others may wish to raise in the chat or the Q&A session later on. So without further ado, a few brief and general remarks on the interaction between the law of armed conflict and international human rights law. It's a common goal that the two areas pursue, that is protecting human beings, and in the case of the law of armed conflict, also certain objects, but there are also important differences between the law of armed conflict and international human rights law, and I want to mention the most important 6 differences. The first one is very obvious. The law of armed conflict applies during armed conflict, whereas international human rights law applies at all times, including armed conflict. There is, however, the possibility of derogation under international human rights law, which is unavailable in the case of the law of armed conflict. Second, and this is very important for the purposes of our discussions and has already been alluded to, the law of armed conflict is presumed to also apply extraterritorially, certainly in the case of international armed conflicts and belligerent occupation, whereas human rights law is, as a rule, at least confined to the territory of a state that is subject to human rights obligations, whereas its extraterritorial application is construed as an exception that only applies if and when an individual is subject to, or sometimes it's called within, the jurisdiction of a state. That is the case for civil and political rights, or under effective control of a state. That is the usual reference in the case of economic, social, and cultural rights, at least according to the Committee on Economic, Social, and Cultural Rights and the International Court of Justice. Now, while the precise contours of being within the jurisdiction of a state in an extraterritorial scenario is somewhat fluid, there's fairly broad, although not universal, consensus on 2 scenarios in which this is the case: effective control over territory, including the form of a belligerent occupation, and effective control over persons, including extraterritorial detention. And this has pertinently been confirmed most recently also in the admissibility decision of the European Court of Human Rights in the interstate application of Ukraine versus Russia, where the Grand Chamber held that Crimea was within the jurisdiction of the Russian Federation for purposes of the European Convention. And importantly also that jurisdiction is being exercised or has been determined to have been exercised both prior and subsequent to the annexation, namely in the period from 27th of February onwards. In contrast, one of the unsettled issues is whether and under what conditions the extraterritorial conduct of hostilities can render persons subject to the jurisdiction of a state, with the Human Rights Committee and perhaps in the present context, less pertinently, the Inter-American Court of Human Rights, answering the question in the affirmative, whereas the case law of the European Court of Human Rights, while not being entirely coherent, I should say, would seem to indicate an inclination to answer the question in the negative. Third difference, the law of armed conflict protects categories of persons, i.e. the protections under the law of armed conflict depend on a person's falling into one or other category that enjoys protection: civilians, prisoners of war, wounded, sick, and shipwrecked, etc. Whereas human rights protections extend to all individuals. The fourth difference, again important in the present context, the law of armed conflict binds all parties to an armed conflict and individuals, thus including non-state organized armed groups, whereas human rights law primarily binds states, and the extent to which others, not the least non-state organized armed groups, are bound remains subject to controversy. Fifth, the rights protected under the two regimes of the law of armed conflict and international human rights law differ in important respects, with international human rights law protecting the full plethora of civil, political, economic, social, and cultural rights. One may also add third-generation rights, while the law of armed conflict focuses on a more limited set of rights. For instance, it is silent on rights such as freedom of expression, the right to marry, a right to social security, and what have you. Sixth, and lastly, the implementation and enforcement mechanisms in the two respective fields differ significantly. And an important example is that litigation in domestic courts and individual complaints mechanisms, either on the regional or international level, are a regular feature of human rights law, whereas they are largely absent, although not entirely absent, from the law of armed conflict. So this all produces a legal landscape in which certain rights are exclusively matters of the law of armed conflict, others exclusively of international human rights law, and yet others matters of both. And the important question for our purposes is how the two fields interact in cases of simultaneous application. And these cases cannot only, I should add, involve non-international armed conflicts, but also international armed conflicts, provided that the belligerent state exercises such control over territory or persons so as to bring those persons into the jurisdiction of the respective state. So in such situations of simultaneous application, the relationship between the two fields is frequently described as being complementary and governed by the lex specialis principle. And I want to just take a few moments to add some more explanation to those two terms. Now, complementarity between the two fields denotes that they are mutually reinforcing, in as much as they complete and perfect, if you will, each other. That mutual reinforcement can manifest itself in a number of ways, which depend on whether a given question is exclusively regulated by the law of armed conflict or exclusively by human rights law, or in the third case, a given question is regulated by both the law of armed conflict and human rights law. In the first situation, the mutual reinforcement takes the form of the law of armed conflict filling the gaps left by human rights law. Think about the use of the Red Cross, Red Crescent, and Red Crystal Emblem, for instance, which is unregulated by human rights law. And here, the pertinent rules of the law of armed conflict apply exclusively. In the second situation, the reverse applies. For instance, since only human rights law regulates rights such as freedom of expression and freedom of assembly, the law of armed conflict is by and large irrelevant to the issue, and answers to questions pertaining to such rights then fall into the exclusive province of human rights law. And in the third situation, where matter is regulated by both the law of armed conflict and human rights law, the applicable law will have to be determined by recourse to the general rule that that priority should be given to the norm that is more specific, the lex specialis maxim. And that maxim is a technique of interpreting legal rules as much as it is a means to resolve conflicts between legal norms. It has been applied much more frequently, actually, as a technique of interpretation, and its origins in the case law of the International Court of Justice was exactly that, the Lawfare conflict coming in as the lex specialis by means of interpretation. But obviously, there's also the scenario in which two incompatible rules under human rights law and the Lawfare conflict respectively meet in a factual circumstance, under factual circumstances. And it is there where the more specific rule actually sets aside the conflicting, more general rule. The case at hand, maybe also interesting for our case, is that the security detention, internment, in other words, of protected persons under the 4th Geneva Convention, or the internment of prisoners of war, are, well, security detentions, which are grounds for detention that are incompatible with the European Convention of Human Rights. And here, the lex specialis maxim as a conflict resolution rule would suggest that the more specific rule, that is the 4th Geneva Convention, Article 5 at Castle, or the 3rd Geneva Convention, set aside the generic rule on arbitrary deprivation of liberty in Article 5 of the European Convention. Reality looks slightly different, and I will return to that in just a minute. So where does all of this leave us in the situations of Crimea and Donbass? First, as far as Crimea is concerned, we already discussed the notion of belligerent occupation and determined, or at least there seems to be consensus, that the Russian Federation is to be considered the occupying power in Crimea. Since occupation implies effective control, and effective control amounts to an exercise of jurisdiction in the sense of human rights law, the Russian Federation is subject to the law of belligerent occupation as much as to human rights law. It means also that certain matters hence fall exclusively into the regulatory reach of the law of belligerent occupation, others into one of human rights law, and yet others are regulated by both areas of law, in case of which the specific question at hand needs to be determined by recourse to the lex specialis maxim. Now, while this may appear more or less clear in the abstract, the application in concrete cases may be more difficult, not the least when considering the possibility of litigation. I want to illustrate that by the aforementioned incompatibilities between the law of belligerent occupation and the 4th Geneva Convention internment provision, Article 5, in other words, with the provision on deprivation of liberty in Article 5 of the European Convention. If one looks into the case of Al-Jeddah, which is dealing with such circumstances, the European Court of Human Rights would, or the jurisprudence of the European Court of Human Rights would seem to point in a different direction than lex specialis, namely that security detention in full compliance with the 4th Geneva Convention would still be in breach of the European Convention of Human Rights. In other words, litigating the issue at hand may lead us down a different path than an abstract application of the notions of complementarity and lex specialis. Second, as far as Donbass is concerned, several issues arise. We touched upon some of those, including whether the Russian Federation exercises effective control over Donbass, which also raises the question of the factual relationship between the Russian Federation and rebel forces in Donbass. And if one could establish that the Russian Federation exercises effective or overall control over the rebel forces, who in turn exercise effective control over that part of Ukrainian territory, the Russian Federation would be subject to the same human rights obligations as in the case of Crimea as a belligerent occupying power by proxy. And I have chosen deliberately here the two alternatives of effective versus overall, because the standard that one has to establish may very well depend on the adjudicative forum in which the argument of occupation by proxy is made, since the International Court of Justice has hinted at the possibility of occupation by proxy, namely in the DRC versus Uganda, the armed activities judgment, but nothing indicates that the requisite level of control is any different from its previous case law, and that is effective control as far as the ICJ is concerned. Now, if the control of the rebel forces over that part of the Ukrainian territory is insufficient to amount to effective control, the armed conflict could still be considered an international armed conflict if and when the requisite level of control, effective or overall, of the Russian Federation over the rebel forces could be established. However, one question that arises here, what would this imply for the human rights obligations of the Russian Federation in Eastern Ukraine? If the control of the Russian Federation over the rebel forces in Eastern Ukraine is determined to be insufficient to internationalize the armed conflict between the rebel forces and the Ukrainian state armed forces, the Russian Federation would still remain subject to a number of residual obligations, including its obligation not to aid or assist any human rights violations committed by the rebel forces, and the obligation to ensure respect for the law of armed conflict by others. That's the so-called external dimension of the obligation to ensure respect. I will leave it at that. There are some controversial elements to it, but for reasons of time, we'll skip that.
Yes, Professor Kleffner, apologies, I will have to ask you to wrap up. Thank you very much.
That's exactly what I would like to do, but just flagging one more issue, namely, what does all of this mean for the human rights obligations of Ukraine for the territory that it has lost control over? And with that, I stop and hand it back to you.
Thank you very much. Thank you very much, Professor Kleffner, for your introduction, for your presentation, which has been extremely, I think, rich also and helpful for our further discussion. Without further ado, and once again asking our dear and most distinguished speakers to pay close attention to the time, as I have limited possibilities of flagging you the remaining time in a non-intrusive manner. I would like to ask to give the floor to Ambassador Marja Lehto, who is both a senior diplomat and a senior expert of public international law from Finland, who has served as an ambassador in bilateral relations and also multilaterally in the United Nations. She has performed very important functions, including presiding over the Special Committee on the Charter of the United Nations and the strengthening of the role of the organization. We are really delighted to have you, Ambassador Lehto, with us today. So I would like to ask you to take the floor and to speak about the topic that has been already announced, namely the obligations of the belligerent parties relating to the environment. The floor is yours, Ambassador Lehto, please.
Thank you, Mr. Chair, for the kind introduction. And I also wish to thank the organizers for the invitation to speak in this timely and important workshop. I have been asked to say a few words of environmental obligations, and I will focus on the work of the UN International Law Commission on protection of the environment in relation to armed conflicts. In the context of this work, the Commission has identified certain environmental obligations that an occupying power has towards the population of the occupied territory, towards the territorial state, and towards other states. The topic as a whole has nevertheless a broader focus and seeks to cover the whole conflict's life cycle, before, during, and after. While I will certainly not have time to speak of all of this, I would like to highlight that the Commission's draft principles have been prepared without expressly differentiating between international and non-international armed conflicts. In addition to the situation in Crimea as one of occupation and illegal annexation, they may therefore have some relevance also to the situation in Donbass, irrespective of whether it is classified as an occupation by proxy, an internationalized armed conflict, internationalized non-international armed conflict, or a combination of an international and non-international armed conflict. Within the 10 minutes allocated to me, I will mostly speak of the 3 draft principles relative to situations of occupation in the ILC work. But let me nevertheless specify at the outset that the Commission adopted a set of 28 draft principles with commentaries on first reading in 2019. This work will be finalized next year in light of the comments received from states, international organizations, and other stakeholders. And regarding my own connection to the Commission's work, let me add that I've been a special rapporteur for this topic from 2017. One of the objectives of the ILC's work on this topic has been to clarify how the existing international law protects the environment in relation to armed conflicts. It was obvious that there was a need for such clarification with regard to the law of occupation, given that the primary legal instruments, the 1907 Hague regulations and the 4th Geneva Convention of 1949, lack specific provisions on the protection of the environment. At the same time, and I think this has already been pointed out in the previous presentations, most of the rules of the law of occupation are of a general nature, and they have proved flexible enough to be adapted to changing circumstances. The Commission has therefore been able to base the draft principles relative to situations of occupation on existing customary law obligations, which have been interpreted in light of subsequent developments in international law. The Commission has also recognized the great variety of different situations of occupation in terms of stability and duration, from occupations lasting a few hours in the heat of hostilities, as in the conflict between Eritrea and Ethiopia, to the more than half century of the Israeli occupation of the Palestinian territories, or 47 years of the Turkish occupation of the northern Cyprus. As a rule of thumb, it can be said that the longer an occupation lasts, the more onerous the obligations of the occupying power. This is something the ICRC says in its commentary to Article 2 of the First Convention, namely that the obligations of the occupier are commensurate to the length of the occupation. In addition to the law of occupation, other areas of international law, such as human rights law and international environmental law, have relevance in situations of occupation. And the more so, the longer the duration. I will now briefly describe the essential content of the 3 draft principles relative to situations of occupation. The first of them sets forth the general obligation of an occupying power to respect and protect the environment of the occupied territory, and to take environmental considerations into account in the administration of such territory. This provision, and I trust that you have the texts of the draft principles which have been circulated last night. This first paragraph of the first draft principle is based on the occupying power's obligation to take care of the welfare of the occupied population, in line with Article 43 of the Hague Regulations. The obligation to ensure that the occupied population lives as normal a life as possible in the prevailing circumstances entails environmental protection. Environmental protection is a widely recognized core public function of the modern state. We can also say that environmental concerns relate to an essential interest of the territorial state, the territorial sovereign, which the occupying state as a temporary authority must respect. This provision further provides that an occupying power shall take appropriate measures to prevent significant harm to the environment of the occupied territory that is likely to prejudice the health and well-being of the population of the occupied territory. The purpose here is to indicate in particular that significant harm to the environment may seriously affect the enjoyment of certain human rights, such as the right to life, right to health, or right to food. Right to water could also be mentioned. This draft principle further requires that an occupying power respect the law and institutions of the occupied territory concerning the protection of the environment, and may only introduce changes within the limits provided by the law of armed conflict. The term law and institutions is intended to also cover the international obligations of the occupied territory or the territorial state. The specific content of this obligation obviously depends on the circumstances of the occupied territory, including the environmental legislation in force and adherence of the territorial state to international conventions on environmental law. The second draft principle relates to the use of natural resources of an occupied territory, an issue of which Professor Bothe already spoke. Let me say at the outset, and I very much agree with Professor Bothe, that there's no general right for an occupying power to exploit the natural wealth of an occupied territory. A number of limitations derive from the law of occupation, and the prohibition of pillage forms an absolute limit to the exploitation of the natural resources of an occupied territory by the occupying power, or by private actors within the area under the occupying power's effective control. At the same time, the draft principles relative to occupation take into account more long-term environmental degradation linked to harmful occupation practices. This is why the one at hand seeks to protect the natural resources of the occupied territory from excessive and unsustainable use. This provision states that an occupying power, to the extent it is permitted to administer and exploit the natural resources of an occupied territory, must do so in a way that ensures their sustainable use and minimizes environmental harm. This provision is based on Article 55 of the Hague Regulations, which regards the occupying power, I quote, only as administrator and usufructuary of immovable public property in the occupied territory. This description in the Hague Regulations has traditionally been interpreted to forbid wasteful or negligent destruction of the capital value, whether by excessive cutting or mining or other abusive exploitation. The Commission agreed in this regard that the established right of usufruct, which basically is a standard of good housekeeping, has to be interpreted in light of the well-established concept of sustainability, and in particular in the context of the sustainable use of natural resources. What this could entail in practice, for instance, is that the occupying power should exercise caution in the exploitation of non-renewable resources. We heard Professor Bothe to say that this is a very problematic question. Renewable resources should be exploited in a manner that ensures their long-term use and the resources' capacity for regeneration. This draft principle also mentions explicitly that the occupying powers' administration and use of natural resources in the occupied territory may only be for the benefit of the population of the occupied territory and for other lawful purposes under the law of armed conflict. The third draft principle in this cluster states that an occupying power shall exercise due diligence, in other words, take appropriate and reasonable measures to ensure that activities in the occupied territory do not cause significant transboundary harm to the environment. This is the established principle that all states should ensure that activities in their territory or control do not cause significant harm to the environment of other states or areas beyond national jurisdiction. The International Court of Justice, in the advisory opinion on the legality of nuclear weapons, has confirmed that this is a customary principle of international environmental law, and its applicability in situations of occupation has also been firmly established. Furthermore, and this is something I can only quickly highlight in view of the time constraints, there are a number of other obligations and recommendations contained in the Commission's draft principles, which may be relevant in situations of occupations, such as those pertaining to the cleaning up after armed conflict, including the removal or rendering harmless of toxic and hazardous remnants, or sharing and granting access to environmental information, and facilitation of post-conflict environmental assessments. In a similar manner, the provisions applicable during armed conflict bear on any active hostilities in situations of occupation. This point of departure is captured in the general commentary, which states that the other draft principles apply mutatis mutandis to situations of occupation, given the variety of different situations of occupation. I believe, Mr. Chair, that I have now used my time. I would be very happy to answer any questions that the participants may have, and I thank everybody very much for your kind attention.
Thank you very much indeed, Ambassador Lehto, for your excellent presentation. Very, very clear, extremely interesting, and also, I think, very much inviting the participants to ask questions, which you said you would be glad to answer, and also for keeping with your timing. Thank you very much indeed once again, and let us proceed to the next speaker. Before we actually can start asking questions, but I invite the participants to formulate the questions already in the chat, and there's already been a question, and please continue along these lines. That would be most helpful. Now I'm very happy to give the floor to Ms. Catriona Murdoch, who is a barrister practicing in international law and a partner at Global Rights Compliance, where she leads the starvation and humanitarian crisis portfolio. She's both a barrister and an international criminal and international human rights law expert, with a very interesting and rich practical experience. She has kindly agreed to speak about the topic, which is one of, I would say, one of the hottest practical topics in the current situation in which Ukraine has found itself with the occupation of Crimea in particular, and also with the armed conflict in the territory, in its eastern regions, namely the obligations of belligerent parties relating to water. So I think that everyone is really very eagerly looking forward to your presentation, Ms. Murdoch. So without further ado, the floor is yours.
Thank you very much for the introduction, and to my fellow panelists. I would like to begin with just a few qualifications. I cannot confess to be an occupation or indeed a Ukraine specialist, so any observations that I make today are my own and are without prejudice to the final opinion that will be produced by GRC, who may well arrive at a different and more likely informed conclusion. But what I hope I can offer is some brief observations on the right to water and the associated prohibitions on attacking or depriving civilians of it, and where along the spectrum that conduct might be considered in and of itself as a war crime. So I propose to touch on three areas. So first, what is the right to water and how is it protected in international law, with reference to the situations in Crimea and in the east of Ukraine. Second, in the event that the opinion concludes that there is an occupation, what might be the principal obligations upon Russia as an occupying force in relation to water? And three, likewise, what, if any, residual obligations might Ukraine hold in relation to water in any part of its territories that may be considered as occupied? But before I outline the right to water and international law, I would like to make just some brief remarks on the cycle of conflict and hunger and water issues more generally. This is an intersection of, that has been an area of work which through GRC I've worked on for the past 4 years, and it's clear to me that it's absolutely essential when confronting the alarming rates of global food and water insecurity that we must reflect on the causal links to that with conflict. And I think what appears to be relatively unknown is really the pivotal role that water is playing in the Ukraine conflict. There is fairly consistent reporting to show that water, like food in other conflicts, may be being used as a tactic to control and leverage gains in negotiation and political positioning. In addition, the right to water itself in Ukraine featured in the UN's Protection of Civilians high-level side event last month, again as evidence of the increasing momentum to prohibit the impact of conflict, and particularly on food, water, and humanitarian aid. So the importance of water has also been really spotlighted and further during the pandemic, with water becoming an essential feature to health to prevent the spread of virus, and I'm sure the panelists after me will have some comments on that. But the right to water more generally in times of armed conflict, including occupation, are governed by the two legal regimes which have already been discussed, so international human rights law and international humanitarian law. And in contrast to the title of this conference, there does appear to be a fair degree of certainty surrounding the right to water itself. Now, Professor Kleffner has elegantly outlined the extraterritorial application of human rights obligations, so I'm delighted that I don't have to go into that again now. Turning to the international humanitarian law protection of water, broadly speaking, and as noted by the ICRC, water is primarily a civilian object, and so it is protected under a variety of different articles. It is also, of course, indispensable to survival and is therefore captured by the protections afforded to civilians under against deliberate starvation. And I think it's important to flag that there is a common misperception that the prohibition of starvation in international law refers only to a lack of food, whereas objects indispensable to survival have been defined non-exhaustively and of course include water. Water installations, supplies and irrigation works specifically are specifically mentioned under the category of objects indispensable to survival in the Geneva Conventions. And the protection extends not just to water, but to the supply itself. So canals, irrigation, dams, cleaning systems, sewage systems, and so on. And these are highly protected objects. The hostile control of dams in particular has been noted to carry specific risks. In terms of conflict classification, in both a non-international armed conflict and an international armed conflict, it is prohibited to attack, destroy, and render useless objects indispensable to survival of the population. So I think, for example, when you see reports in the east of Ukraine of repeated shelling on water facilities and infrastructure, and where the water pipes there are snaking across numerous different front lines, have become damaged or indeed rendered useless, this would engage that specific prohibition in IHL. In addition to a lack of access to water, and touching upon Ambassador Lehto's presentation, there is also the serious environmental impact of the repeated attacks on water facilities. And again, these have been well documented in Donbass, including, just to mention two, the release of liquid chlorine and air pollution as a result of attacks, and the discharge of sewage and untreated industrial waters into reservoirs and rivers. Pivoting slightly, conduct such as blocking a water supply that restricts civilians' access may also be considered to cause a deprivation under IHL. And it's important to note in the context of Crimea that starvation can also result from omissions. So deliberately refusing not to take measures to supply the population with water, which is indispensable, would in a way become a method of combat which itself could become prohibited. So when Russia annexed Crimea in 2014 and the main canal servicing Crimea Ukraine constructed a temporary dam, and this was replaced 3 years later by a permanent one. This canal used to supply Crimea with approximately 85% of its drinking and irrigation water. Whether this act of constructing the dam and any subsequent omission to supply water violates international law would again warrant further exploration and is indeed going to be covered in the legal opinion. Turning then to the international human rights of water, this has been declared an essential human right, and it can be found across a host of treaties, including the International Covenant on Economic, Social and Cultural Rights, and also what are known as the Berlin Rules, aimed at codifying customary international law relating to water. As with food, the right to water is inherently linked to the right to life, and it is protected and deemed to have a similar status. The right to water, as with other economic and social cultural rights, impose a threefold obligation upon states to respect, protect and fulfill. And of course, there is no derogation clause under the International Covenant on Economic and Social and Cultural Rights. A final provision to bear in mind is that the right to water is also enshrined in Ukraine's national constitution, which includes a right to a healthy and safe environment. It is worth noting that the Committee on Economic, Social and Cultural Rights has stated that a violation of the obligation to respect would include the arbitrary or unjustified disconnection or exclusion from water services or facilities. Moving then to how these violations or potential violations or breaches would move into criminal conduct is something that GRC have focused upon in a range of different contexts over the last 4 years. Currently, we're working with our Yemeni partners in Motana in a year-long investigation on attacks on objects indispensable to survival in the Yemen conflict. And here we are looking at, amongst other things, a pattern of airstrikes against water facilities. And it struck me that there may be some parallels, indeed, when we're looking at some of the reports from UNICEF, who've registered 387 attacks on water facilities in the East since 2017, with the most recent attack just registered in the middle of last month. 35 water workers have been killed and injured, and there's an estimated 500,000 children in need of clean drinking water in Ukraine. So you could envision with that kind of factual scenario how further investigation into the proportionality and legality of such attacks on those facilities may well be warranted. It is important in terms of international criminal law just to flag that for the war crime of starvation, in addition to the physical elements, a prosecutor would need to establish that the warring party intentionally deprived civilians of water and intended to do so as a method of warfare, which really in practice and having gone through some of these investigative works with our partners is a high threshold to satisfy. Turning then in terms of what the obligations might be upon an occupying force in relation to water. Here, and I think the other panelists have outlined, that the legal frameworks here seek to strike a balance between the interests of the local population and those of the occupying army. And it is clear that IHL imposes a duty to ensure that the population of an occupied territory has adequate access to water. And so an occupying power, such as Russia, shall carry out all governmental functions to ensure the normal daily life of the civilian population, its welfare and its social functions. So on the face of this would require Russia to pursue water policies such as securing the social life and survival of the civilian population. And again, you see the language of starvation and survival being echoed here. Second, to maintain at a reasonable level the material conditions under which the population of the occupied territory lives. And then, if the whole or part of that territory is inadequately supplied, the occupying power must agree to relief schemes on behalf of the population and should facilitate them at all means to its disposal. And then finally, and again touching on the previous panel, it must prevent, anticipate and minimize any environmental harm. Looking then at international human rights law, and again as touched upon by Ambassador Lehto, a prolonged occupation makes it increasingly necessary for an occupant to take into account the economic and social needs of the local population. And this would require, in these circumstances, Russia to implement a long-term strategy for how they would see the progressive realization of these economic, social and cultural rights. But of course, how far do these positive obligations extend? And I think this is here where the uncertainty arises in practice. The covenant itself allows for the possibility that a state may not be able to put all of its duties into effect immediately in the notion of the progressive realization, and it will take into account a state's available resources. But under human rights law, it's not simply a question of budgetary capabilities. Even without significant resources, the progressive realization would not remove Russia's obligation to recognize the minimum core rights and at least to have steps in the direction of supporting that. Turning finally then to what extraterritorial obligations Ukraine might hold in relation to water in any part of its territory that's considered occupied. A state which has lost control over its territory as a consequence of foreign occupation remains bound by the negative obligations towards its population and is obligated again to provide the core minimum rights. There does appear to be a particular consensus in such situations that these minimum core obligations will include the right to be free from hunger, basic health care, clothing, and basic shelter. And these are, of course, inherently, as I've already mentioned, linked to the right to life, as without them, the survival of those population could not be guaranteed. I think where that tension and the uncertainty arises again is, of course, in upholding these minimum core obligations. That poses itself a complex tension within international law, which recognises the right of a state not to acquiesce to the unlawful annexation of their territory. So I hope that those observations have highlighted some of those tensions, and I thank you again for your time and for the opportunity to spotlight this really important issue.
Thank you very much indeed, Ms. Murdoch, for this presentation, which I think sets out the scene perfectly, and I very much hope for a lively discussion afterwards. But before that, we have last but not least another very I think very exciting topic, which we certainly all anticipate eagerly. This is the obligations relating to health, in particular, including the situation with the COVID-19 pandemic. And we have a distinguished speaker to cover this topic. This is Mr. Eitan Diamond, who is manager of the Diakonia IHL Center in Jerusalem, who used to work as a legal advisor for the ICRC delegation in Israel and the occupied territories, and also as a consultant for the Office of the High Commissioner for Human Rights and the UNICEF and other international bodies and organizations. And as you understand from already from this introduction, he intimately knows the issues of the law of belligerent occupation. So I would like to pass the floor to Mr. Diamond straight away, and also to invite the participants to continue putting their question in the chat. That would facilitate the beginning of our questions and answers session. So Mr. Diamond, you have the floor, please.
Thanks very much. So first of all, I'd like to express my gratitude to the organizers for inviting me to speak. I'm really glad for the opportunity to join you in this important debate. I must say, though, that I'm a little less pleased that lessons from the Israeli occupation of Palestine are relevant elsewhere. It would be nice if we had happier exports to discuss. I will note, as was observed, I have some experience in relation to belligerent occupation, and I will speak about the law. What I don't know much about is the particular context that this event is focused on. And so I will speak about the law in abstract and add perhaps some observations from a different occupation, from the Israeli occupation of Palestine, in relation to this issue, which hopefully will nevertheless be useful for people to draw relevant insights about. A couple of preliminary remarks. So first of all, in terms of the scope of this presentation, I'm going to be speaking about obligations relating to health in situations of occupation, and will not be addressing belligerents' health-related obligations in other situations of armed conflict. A distinguishing feature of situations of occupation is the fact that the occupying power has effective control over the civilian population of the occupied territory. In a way, they are in its hands. And because of this power over the population, and because of a governmental vacuum that's caused by the ousting of the sovereign of the territory, the occupying power has robust obligations. It's obliged, as it were, to step into the shoes of the ousted sovereign and to perform the basic governmental functions that the sovereign can no longer perform in its place. And this includes functions relating to health services, or the provision of health and securing the right to health. The second point that I'd like to make here is that at the Diakonia IHL Center in Jerusalem, we've recently grappled with questions about the scope of an occupying power's obligations in relation to health when analyzing responsibilities in response to the outbreak of COVID-19 in the occupied Palestinian territory. And our publications on this matter are available on a web page, and I'm going to try to link on the chat right now as we speak, primarily because I won't be able to cover all of the ground that we do cover there. But perhaps to begin with, somewhat more in abstract, to discuss the relevant law. And as we've heard from previous speakers, the occupying power's international obligations with respect to various services, including health, derive from international humanitarian law, of course, in particular the area of international law, international humanitarian law that forms the law of occupation in the Hague Regulations of 1907 and the Fourth Geneva Convention primarily, and also from complementary provisions of international human rights law. And we've heard from Professor Kleffner about the complementary applicability of human rights law in occupied territory, both as an independent source of law, but also as a source that informs the interpretation of international humanitarian law, filling gaps that may exist in international humanitarian law. And as we'll see, this gap-filling function is relevant with regards to health-related obligations under international humanitarian law. So I'm going to discuss some of the key provisions in both of these two legal frameworks, and I'll begin with IHL. And there are 5 main provisions that I'd like to highlight. First of these is a really foundational provision of law in the law of occupation. That's Article 43 of the Hague Regulations of 1907, under which the occupying power is responsible for ensuring public order and civil life. And civil life is really the important notion here. And this is a notion that covers many aspects of life, including economy, education, welfare, and health. This, by the way, is confirmed, among others, by the Israeli Supreme Court in its considerable jurisprudence on the law of occupation. So that's in the Hague Regulations. And then there are a number of provisions in the Fourth Geneva Convention that are important here. The first of these is Article 55 of the Fourth Geneva Convention, which establishes that in an occupied territory, the occupying power has a duty to provide, among other things, medical supplies. And this is a duty to provide. It's important for me to highlight, this isn't about letting others provide. The occupying power itself has an obligation to provide these medical supplies in the first place. The second article is Article 56 of the Fourth Geneva Convention, which states, among other things, that to the fullest extent of the means available to it, the occupying power has the duty of ensuring and maintaining, with the cooperation of national and local authorities, many things, including public health. And this includes taking measures to combat epidemics. This is stated specifically in Article 56, and for that reason, there was a lot of reference to Article 56 in discussion about the occupying power's responsibilities, or the division of responsibilities with respect to COVID-19. And there was a lot of reference also to the fact that the occupying power is supposed to cooperate with national and local authorities. And some had suggested that the brunt of the responsibility is on the national and local authorities. I'll relate to that a bit more in a moment, although I would point out already that ultimate responsibility on our analysis rests with the occupying power. Another provision to highlight is that of Article 59 of the Fourth Geneva Convention, which relates to relief efforts and relief supplies, and including medical supplies. And it establishes that if the whole or part of the population of the occupied territory is inadequately supplied with these kinds of supplies, then the occupying power shall agree to relief schemes on behalf of the population and shall facilitate them. So it has to allow and facilitate the provision, the passage of relief by others. So I mentioned before its own obligations. It also has obligations not to obstruct and to in fact facilitate the provision by others. And finally, Article 61, which is quite closely connected to Article 59 for this purpose, establishes that the occupying power shall facilitate the rapid distribution of relief consignments. So again, an obligation to facilitate when others are providing assistance. So that's a brief overview of some of the key provisions in IHL. Turning now to international human rights law, and here really the key provision is found in Article 12 of the International Covenant on Economic, Social, and Cultural Rights, which establishes in its first paragraph that the states parties to the present covenant recognize the right of everyone to the enjoyment of the highest attainable standard of physical and mental health. And it later specifies that the steps to be taken by state parties to the present covenant to achieve the full realization of the right shall include those necessary for, among other things, the prevention, treatment, and control of epidemics. That's part of the obligation. So that's a provision in human rights law that has been clarified by the UN Committee on Economic, Social, and Cultural Rights, which is responsible for monitoring the implementation of the covenant. And it clarified in its general comment 14 that this right to health includes essential elements, availability, accessibility, acceptability, and good quality of the health services provided. Now, of course, these elements have to be, respecting them is essential for complying with human rights law, but I would point out here that they are also important to give meaning to the IHL provisions that I rapidly outlined before. So, for example, in order to understand what ensuring public health is, this term used in Article 56 of the Fourth Geneva Convention, it's important to refer to human rights law and to these requirements that exist under human rights law. And another really important principle that is introduced by human rights law is that health services are to be provided in a non-discriminatory manner. And that should inform, in our view, the interpretation of the IHL provisions as well. So non-discrimination between the protected persons within the occupied territory, but in our view, also non-discrimination between the occupying power's own population and the population of the occupied territory. So that's a kind of quick overview of the provisions of law relevant here. Now I want to just touch on how these apply in a concrete case. Again, this is not in the context that we've been discussing so far. This is the case of obligations with respect to the provision of COVID-19 vaccines in the occupied Palestinian territory. And I think this example that we've, as I said, looked at quite closely might be instructive elsewhere as well. So I think one can identify three layers of obligation there based on the sources that I've been discussing before. The first of them is a duty to supply the vaccine, or more broadly, health services. That means an obligation to ensure basically that these, in this case, the vaccines reach the occupied territory. That's an obligation that in the case of the Israeli occupation of Palestine, and you can exchange, I suppose, Israel for another occupying power and Palestinians for another occupied population. But what it means is that Israel, as an occupying power, as part of its duty to ensure civil life that I mentioned before from Article 43 of the Hague Regulations, and its duty to ensure medical supplies for the population, has an obligation to supply the vaccine, to ensure that it gets to the occupied territory. It must make the vaccines available to the population under its control without discrimination. That's drawn from human rights law. And that means the population under its control is all of the population under its control, including its nationals and the residents of the occupied territory. And as an occupying power, it must allow and facilitate the passage of medical supplies provided by others. We saw that's Article 59 of the Fourth Geneva Convention that I mentioned before. So that's the obligations with respect to supplying, getting the vaccines, in this case, into the occupied territory. It also has, the occupying power also has a duty to ensure the safe and rapid entry of vaccines into the occupied territory. So you get it to the border, you then have to ensure that it gets into the occupied territory. So the occupying power bears primary responsibility for ensuring this entry. That's part of its obligation to supply the vaccine, but also derives from its duty not to impede and to, in fact, facilitate the provision of vaccines. And relevant provisions here are Article 59 and 61 of the Fourth Geneva Convention that I mentioned before. That means that it must refrain from hindering the passage of the vaccines and is obliged to take positive steps to facilitate such passage. That would be things, for example, like reducing the administrative procedures that one has to work through in order to facilitate that. So that's getting the vaccines into the territory. And now we come to the distribution within the occupied territory. And that's a slightly more complicated case because international humanitarian law, in fact, encourages an occupying power to leave responsibilities with local authorities. We saw Article 56 before, which actually establishes a duty to coordinate with local authorities when it comes to provision of health services. So when it comes to distribution within the occupied territory, at least in the case of the occupied Palestinian territory, but I think this would be true elsewhere as well, the occupying power has a duty to support the local authorities in their deployment of the vaccines or other medical services by all appropriate means. And that derives from Article 56 of the Fourth Geneva Convention that I mentioned before. That means it has to allow and facilitate the passage of vaccines within the occupied territory. In the case of the Palestinian territory, that means, among other things, that it has to allow passage from the West Bank to Gaza with Israel being in the middle of that, between those two parts of the occupied territory, might unfold differently in other contexts, and it must refrain from hindering access to safe and effective vaccination for the local population. Now, I could stop there. Perhaps I should for time. Otherwise, if I have a few more minutes, but we can also do that in questions, I could relate a bit to third states obligations. But I think perhaps better to stop here for now.
Thank you very much.
Yeah.
Yes, thank you very much, Mr. Diamond. Thank you very much for being so precise with the timing. The question about the third states is certainly very relevant, and let us consider that it has already been asked. So when we have the questions and answers session, I would invite you to respond to it, because certainly there is this question. And now, thank you very much once again to our distinguished speakers. We have, I think everyone has listened with great attention and interest to these brilliant presentations. We have a little bit of time. We are supposed to finish in some 12 minutes, but as the session started 5 minutes later, I would assume that we have at least 17 minutes more for the questions and answers. Some questions have been asked, so let me then read the questions that have already been asked, and also if somebody in the meantime types their question in the chat box, I would also read theirs, and I would then take advantage of my privileges as the moderator and ask maybe a question or two myself. So let me start with a question from Professor Dino Chrytsiotis to Professor Jann Kleffner. Professor Chrytsiotis is saying that Professor Kleffner spoke most eloquently about the difference between the breadth of human rights when compared to the rights in inverted commas assigned under international humanitarian law. But there is also a difference in the form that these rights assume, quite apart from the question of their scope, which is where most likely Professor Kleffner's comments were directed. So when Article 8 of Geneva Convention 4, already referenced in the earlier panel, speaks of the rights secured, is it referring to human rights, or these are merely individual rights akin to those announced by the ICJ in its Avena judgment in respect of the Vienna Convention on Consular Relations, or where these Geneva Convention rights originally articulated as individual rights, but which have since, so to say, become human rights, at least in part. So this is the first question, which is addressed to Professor Kleffner. I would invite Professor Kleffner to take this question, and then we'll continue with the question to Ambassador Lehto. So Professor Kleffner, you have the floor.
Thank you very much. That's an exquisite question. Thank you very much for that. Well, to answer it, I mean historically, I think the law of armed conflict has always been conceptualized as establishing primarily, at least, horizontal relations between parties to an armed conflict rather than vertical relations between a party and individuals. As a starting point, I think that's where we have to go. Although we find obviously references to the notion of rights in the law of armed conflict, but I'm fairly certain that they were not thought of as invocable rights of human rights, in other words, if I understand your question correctly in that way. What has happened since is, well, a certain process of, can we call it human rightsization, in which individuals have invoked human rights proper under the covenant, for instance, under the European Convention and so forth, that overlap in substance, at least to some extent, with rules of the law of armed conflict. And through that process, I think the thinking of rights in the law of armed conflict as human rights has entered the arena. Having said that, attempts to directly invoke rights under the law of armed conflict in front of domestic courts, for instance, has proved to be fairly unsuccessful. I'm thinking of German case law, for instance, the Relevant Bridge cases or case and similar, where one has sought to invoke rules of the law of armed conflict. In other domestic jurisdictions, one has tried to do that by combining the compensation duty clauses in the Hague regulations and the first additional protocol together with rights as they occur in the law of armed conflict. Again, to not much avail. At the end of the day, I think obviously much will depend on the domestic system in question, how that domestic system would entertain a litigation invoking directly rules of the law of armed conflict. But I would suggest that the form that you're referring to is indeed different in those two areas of law. Thank you.
Thank you very much, Professor Kleffner. So I think that the point is absolutely taken. Now the next question comes from another eminent authority in this field, from Dr. Marco Longobardo to Ambassador Lehto. The questions relate to the draft principles developed by the International Law Commission. Do these principles provide any rule that cannot be already derived from current treaty law? And in any case, to what extent do these principles codify or crystallize or progressively develop customary international law? So this is a question of more on the theoretical side of it, but I think it's nevertheless a very interesting one, or very interesting questions. Ambassador Lehto, you have the floor, please.
Thank you very much, Mr. Chair, and thank you to Marco Longobardo for a very interesting question. If we speak of the three draft principles relative to situations of occupation, they are clearly based on the Hague regulations, derived from the Hague regulations. And they are based on international customary law, since the Hague regulations have the status of customary law, no doubt about that. The added value, I think, is that these draft principles expressly spell out certain environmental obligations of an occupying power. This has been actually a neglected area in international law. One of the very few documents that pay any attention to the environment of occupied territories is the 1992 Rio Declaration. There is one principle that says the environment and natural resources of people under oppression, domination, and occupation shall be protected, unquote. I think it's telling that 20 years later, there was a UN report that reviewed the implementation of the Rio principles. And regarding this one, it only stated that undoubtedly there were several instances of depletion and degradation of the resources and the environment of occupied territories, but that ultimately the international law relevant to this principle is surrounded with ambiguities. So I think there really has been a need to clarify how you can read the established obligations of the law of occupation in relation to the protection of the environment. And what the Commission has done has been to interpret these age-old obligations in an environmentally friendly way. What I should add is that the principles as such are fairly general, but the commentaries, which are an essential part of the ILC work always in every topic, they contain more detail on how international human rights law and international environmental law complement the law of occupation. Your other question concerning crystallization, codification, crystallization, or progressive development, I think there we should go to the other draft principles. And I would take an example of the two draft principles that deal with corporate due diligence and corporate liability. Very briefly, they ask states to ensure that business enterprises operating in conflict-affected areas, and this of course includes situations of occupation, that these business enterprises exercise environmental due diligence, and that they can be held liable if they cause damage to the environment or public health. This is an area that is really on the move. There have been several developments in the context of business and human rights. There's binding regulation at the national level and in the regional level, for instance, in the European Union. There's lots of relevant national and regional jurisprudence. The ILC draft principles build on these developments, and I think where they can contribute is to consolidate an emerging rule of customary international law. They can influence further legal developments, but it's clear that the customary international law is not yet there with regard to corporate due diligence and liability, and therefore the draft principles have not been cast in mandatory terms. I hope these few examples satisfy your interest. Thank you very much.
Thank you very much, Ambassador Lehto. This is most elucidating, very interesting, and of course the topic, and especially the aspect that has been raised by the questions is really enormous, and we okay, thank you very much for your wonderful answer. And now we have more questions, and in fact we have a question. As you know, there is the live streaming of the conference on YouTube, so there is a question from the live stream audience to Ms. Murdoch, which I'll try to summarize the question. So one of our listeners is asking whether the cases expressly mentioned by Ms. Murdoch, I guess, they raise the issue of the right to water in the context of armed conflict, and could this be an avenue to explore for Ukraine in terms of bringing Russia to responsibility at the international level? And let me complement this question by a different aspect, the one that I think you have already mentioned, and the one that is probably the hottest in the public domain, namely the question, of course, of the supply of water for Crimea from the Dnieper River. And as you mentioned, we're talking about resources and the obligation to provide resources which are indispensable for the civilian population. So the argument advanced by Ukraine, as you're of course well aware, is that in fact there is enough potable water for the needs of the civilian population in the occupied Crimea. The problem, though, is that the water is extensively being used for the needs of the occupying army, and that's why it results in shortages for the civilian population. So I would be very grateful to you, Ms. Murdoch, for your comments and for your thoughts on these two rather diverse questions. But I guess they more or less go in the same vein. So the floor is yours, please.
Thank you, and I think both are very important questions. In terms of whether there has been any international cases that deal with this, there has been a real significant lack of international attention on conflict in hunger and conflict in its impact in relation to the right to water. As far as our research over the last few years has shown, is that there has been only 2 international cases where this has been touched upon, in Croatia and in Ethiopia, and both of those were trials in absentia. I think broadly speaking, I would say that absolutely, I think this is an avenue that should be explored on the international level, and responsibility for the attacks on water facilities in the east, seemingly conducted by Russian forces. I think that is ripe for further investigation and exploration. I would think that the case, or the sort of case study, I suppose, that closest that comes to mind with that would be there's a Eritrea and Ethiopia Claims Commission. And that was in 99 and 2000, where Ethiopia were attacking a water reservoir by a campaign of airstrikes. And the commission examined the lawfulness of those attacks and particularly looked at, as with parallels as we see in the east of Ukraine, the pattern of those attacks and what seemed to show a repetition on specific water facilities and sites, and the impact that that in turn had on the local communities' access to water. What they found was that there was a breach of Article 54 of the Geneva Conventions, and that they had prohibited the civilian population of water, which they, of course, classified as an indispensable to survival. And they noted that that prohibition, of course, is very much widely accepted in customary international law. So I would say that that would be a useful, albeit it's not a case, a piece of information from that Claims Commission as to how they analysed that specific issue. I would probably, in terms of whether there were other attacks on water facilities in other conflicts that have gone through international courts and tribunals, trying to rack my brains whether there was anything specific in the Balkans, in the former Yugoslavia, and I would defer to Wayne's Jordash's encyclopedic memory on that. I don't think there was anything specific in jurisprudence there, but I think my short answer would be that yes, it would be something that I would strongly advise would be a point of investigation. And if the documentation by the likes of UNICEF and others who are collecting that information is anything to go by, it does seem to indicate that there is a pattern of attacks. In terms of the second question and how the deprivation of water, again, it's a very difficult one as to how to separate the civilian water supply from a military water supply. And that is a particularly thorny issue, really, in terms of how you would go about doing that in practice. I think what's important probably to flag in that context is the covenant itself in terms of economic, social and cultural rights, the general commentary on the right to water. In relation to that is that there is an undertaking on both parties to guarantee that the relevant rights will be exercised without discrimination. So on that basis, there would be an obligation to supply water without discrimination, both to the civilian population and to others who in practice may be utilising it. I think going beyond that, my preliminary view would be that given that there is a minimum obligation upon Ukraine to supply the civilian population, I think that in practice applying with that obligation when limiting the water supply to the military, I think would carry the risk in and of itself of violating that minimum core right, if that makes sense. I think, certainly it's a thorny issue, and one that I would, is as I say, is going to be covered in the opinion and will be elaborated in more detail there. But my preliminary view would be that trying in practice to separate those supplies from civilian to military would be complicated.
Thank you very much, Ms. Murdoch, for these answers. Again, I think we just touched the tip of the iceberg, and certainly then there's so much to discuss about this. Thank you very much for this, and I ask for the audience's indulgence. And there's still a question, an important one, to Mr. Diamond concerning the obligations of the third parties in respect to the health-related obligations in the occupied territories, and certainly. Once again, there is a whole set of issues relating to, for example, in the case of Crimea, to the very harsh international sanctions imposed on anyone dealing with the occupied territory and so on. So, Mr. Diamond, the floor is yours, and I invite you to state your views the way you like, but as briefly as possible. Thank you.
Yeah, also, I'll say very in short, and this will obviously not enter all the details. So I think, first of all, it's important when it comes to health, at least, that there's an obligation to assist to the maximal extent possible in realizing the right to health that derives from the right to health under human rights law. So that would be the first thing I'd say. Secondly, there's a duty not to aid or assist in the commission of violations. That arises from customary international law. So Article 16 of the ILC draft articles is perhaps a source one could turn to identify the customary norm. And finally, states have an obligation, and this is derived from IHL, particularly from Common Article 1 to the Geneva Conventions, to exert influence to ensure respect for IHL and to put an end to violations. So to the extent that violations of IHL undermine access to health or third states have a role in actions by an occupying power in breach of its obligations with respect to health, then Common Article 1 would kick into play. So that's, I mean, at a very kind of architectural and quick level, obviously more to be said. Thanks.
Thank you very much for this, Mr. Diamond. I think you just gave the right the right keys to this issue, and of course this is to develop. And also thank you very much for handling Mr. Yurov's question concerning Article 43 and its interpretation. I assume that everyone agrees with the answer you gave. Well, I for one do certainly. Thank you very much once again. And before completely wrapping up, I would like to thank, first of all, very much our distinguished speakers for your presentations, for the answers, for opening the wealth of issues that certainly will provoke and I hope will stimulate our participants to think about them and perhaps to research them. And now I think we have come to the end of our second panel, and I will return the floor to the organizers. I think to Ms. Bothe for the words of conclusion of the first day. Thank you very much once again, and thank you very much to the audience for your questions and for your attention to our panel. Thank you.
Thank you, Mykola. I'll just join you in thanks for our moderators, panelists, interveners, and all of our audience for joining us in these very important discussions today. We hope to see you all again tomorrow, where we'll have 2 new panels on obligations in relation to specific populations affected by the conflict and roles and obligations of third parties in the Ukrainian context. We'll begin again at 9 a.m. in The Hague and 10 a.m. in Kiev, and we hope to see you then. Thank you.
Thank you.
Thanks.
Thank you.
Thank you.